Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Just an FYI, we made a bunch of changes here in the studio yesterday, and it's completely changed how this show is going out to you, and that's to make room for future upgrades in January. Everything should be working. It should not be any different for you, but if you see something that isn't right, please let me know so I can make corrections on the fly. Let's go ahead and start our morning with Judge Simpson.
Okay, I'll pass that one too. Third time's a charm. Court calls the case People versus Chanel Griffin. Miss Pate is here, and I think your client is in Zoom.
Assistant Public Defender, on behalf of Ms. Griffin. Oh, can you please state your name for the record, ma'am?
I'm here.
State your name.
Chanel Griffin.
Go ahead.
Thank you, Your Honor. Me and Ms. Griffin had the opportunity to review the PSI. We only have one update. I believe since the report has been written, Ms. Griffin states to me she has taken care of her outstanding warrants. Outside of that, we have no corrections to the report, and we would respectfully request the court adopt the probation's recommendation for the sentence.
All right. Ms. Griffin, anything you want to tell the court before I impose sentence? Question mark.
Ms. Griffin, was there anything you wanted to say before the judge imposed sentence?
Oh, I'm sorry. No, sir. I didn't. Oh, maybe
Right.
you guys hear me. I'm sorry.
Sentence of the court, $480 fines and costs, 93 days in jail, suspended. When can you pay the fines and costs, ma'am?
I can have it paid off in, I say, like 90 days.
She say 90?
I believe so,
90.
Your Honor.
90?
Yeah.
Like
90
90?
90, yeah.
Well, you're gonna have to do it a little bit sooner than that. I'll give you to February 28th, 2026. All right, thank you.
Thank you so much.
Thank you, Your Honor. Thank you, Ms. Griffin.
Thank you.
Court calls the case People versus Ethan Ryans.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ryans, who appears on Zoom. Sir, please state your full name for the court.
Good morning, Ethan Ryans.
Go ahead.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity to review both the assessment as well as the recommendation from probation, which I have had the opportunity to review with Mr. Ryans. He does just have one request as to the sentencing recommendation. We're asking if the court would consider not imposing the twice weekly, or in the alternate, consider possibly only once weekly of the AA classes. Mr. Ryans does state to me that he continues his enrollment in school. It's my understanding that he's taking 16 credit hours as well as working during this time to earn money. He does have some concerns about both keeping up his schooling with his job if he is attending 2 of those per week. To my understanding, he has been completely compliant on his bond, and this is the first defense of something of this nature. Outside of that request, Your Honor, we would ask the court to adopt probation's recommendation.
Sir, is there anything you want to tell me before I impose sentence?
No, sir. Pretty much as my attorney has stated, I've tried my best to stay compliant with my tether. I have quit alcohol earlier this year in April, and I plan on keeping that track. So,
Where are you in school?
Washtenaw Community.
What are you going to be when you grow up?
Currently, I'm studying business administration and looking to transfer over to Michigan State with fall 2027
where?
enrollment.
To where?
Michigan State. That's where I'm looking to transfer to for management.
Why? For God's sakes, why?
A lot of people feel like I'm betraying you, Mish, but honestly, I feel like the competitiveness
You
at
miss that might get worse. Why are you going to transfer into state?
I feel like the environment is just a little bit better for me. The competitiveness with
Have
U
you
of
ever
M.
been there?
No, I took a tour there back when I was
It's like
17.
you took a tour at 17 and
Yes,
it took
sir.
forever, didn't it? None of the
It-
buildings are together. The whole place is like spread out.
yeah, the entire city is the campus.
Yeah. So you really want to be a Spartan?
Yes, sir.
Well, we might have to change this sentence. All right, young man. Well, I wish you all of the best, and I'm just teasing with you. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court that you are placed on 18 months probation. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you pay that?
Give me about 48 hours, please.
48 hours?
Yes, sir.
Oh, I like you. All right. I'll tell you what, pay it by the 26th, okay?
Yes, sir.
Has the Spartan ever told me yes, sir? No, he's gonna be the first.
I have.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victims' impact panel attendance to probation. You continue the scram tether an additional 30 days in lieu of 5 days in jail. All order 93 days in jail that is suspended. Thank you.
Thank you.
Thank you, Your Honor.
And sincerely, young man, good luck to you.
I appreciate you. Thank you.
Good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. Judge Simpson is in a good mood. That's always nice to see. Barbara, thank you for the $5. I very much appreciate that. Nice way to start the day. In a little bit, maybe 15 or so minutes, we're going to have a brief story time with Dan. There's something I want to share with you guys, but we'll ride with Judge Simpson a little bit first.
Opportunity to review both the assessment as well as the recommendation from probation. As to the recommendation, we are respectfully requesting that the court adopt it.
Sir, is there anything Ms. Blair?
Your Honor, Teresa Clare on behalf of probation. I would just like to make the court aware, I did receive Mr. Williams's victims impact panel attendance. Also, so the court is aware, Mr. Williams is already on probation with me on another matter. This case is not a violation of that case. It happens prior to the.
Got it. All right, Mr. Williams, anything you want to tell me before I impose sentence?
No, thanks.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of substance abuse and mental health treatment. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I'm going to place you on 24 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I will waive the probation oversight fees. When can you get that paid, young man?
I was wondering if I can work out a payment plan with my probation officer.
Is he already on a payment plan?
Yes, Your Honor.
All right. There'll be a payment plan as directed by probation. Understand that?
Yep.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a dual diagnosis programming, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, which is completed. I'll order 365 days in jail, credit 42. The balance is suspended. Right. Thank you, sir.
Thank you.
Thank you.
Thanks, Mr. Williams.
Barbara throws down another $5. Thank you so much. But I'm going to go ahead and do story time now real quick. Bear with me for just 2 or 3 minutes, and then we will get back to court, but I think this is important. So you guys know, if you've followed us here at TCF for any amount of time, just how important our animals are to all of us. I mean, I've got Ellie here with me right now. Good morning, sweetheart, by the way. She was a terror last night, but all of a sudden, yep, flop down, have me pet your belly. I see how you are. So anyways, our animals are important to us. So some of you already know the story, but about a week, 10 days ago, something like that, I caught on one of our Ring cameras a rabbit that was running around that looked a lot like one of our rabbits. And members know we even have emojis for Floppy and Verity, who are our 2 rabbits. But the good news is it wasn't one of our rabbits, but it was a rabbit that was definitely a domesticated one that somebody had cut loose. And I always hate to see that, but it happens. So I chased this rabbit around the neighborhood trying to go ahead and get it, because it won't live outside. Domestic rabbits don't have the instincts, but people get them and they cut them loose because they're not what they think that they're going to be. They think when they're getting a pet rabbit, they're getting something like a hamster, but to be truthful, you're getting more something akin to a cat or a dog for the needs that it has. So anyways, I chased this rabbit around the neighborhood trying to get it and broke a toe in the process. But I wasn't able to, and we put out a humane trap to try to catch it, to be able to give it a home. But we weren't able to catch it. But a neighbor did over the weekend, and we had been communicating via the Ring app about this rabbit, and we went ahead and she was able to get it. And she reached out to me, and what I had said all along was, if somebody can catch this, I'll go ahead and make some phone calls, try to get it at the Humane Society or a rabbit rescue and get it adopted. Humane Society has no capacity to take it right now, and the rabbit rescues around the greater Phoenix area where we're from aren't taking any rabbits right now. One that I talked with has actually, get this, had 1,600 requests to take in rabbits just this year. This is how prevalent this problem is of people getting pet rabbits and not being able to care for them. You're so sweet. It's sad. So, yeah, 1,600, Michael, it's crazy. So, we talked about it. The problem that we have here at the bunker is that our rabbit room is full up. We don't have room for it. And to be truthful, with rabbits, unless you get them together when they're babies, they tend to become very territorial, and you have to spend a whole lot of time getting them to bond with each other, or they will kill each other. They will get violent with their own, where with everybody else they'll run away. So, Grandma TCF is stepping up to the plate. She decided that she wanted to take this rabbit in and make some space for it in her wing of the TCF bunker. So we're waiting for a couple things to come in, but later today we're going to go pick up this rabbit from the neighbor who's been nice enough to keep it in a kennel that they have for the last couple of days, and it's going to be our rabbit. And let me go ahead and pull up a picture to show you what we're looking at here. That guy right there. Right now we're just calling it Bunny. I don't know if it's a boy or a girl. It's probably 1 to 2 years old is my best guess. I have seen the rabbit. I went over to the neighbor's house, spent some time with it. Very compliant bunny. I think it'll be a good pet for us. It's not going to have quite the fancy digs that the other two have, but it will be safe and it will be cared for. So I bring all this up because I'm going to do this. And you are under no obligation, but I bring it up because Barbara has already thrown down $10 today. Any super chats we get during this show today, any super thanks after on the on-demand version, and any donations made today at courtroomfiles.com, they will go and be earmarked for the immediate care of this bunny. It's going to need a vet visit. It's going to need to, have its shots, things like that. Anything left over, we will go ahead and we will send to the Humane Society here in Arizona. So you're under no obligation, but if you would like to help out, that's where today's super chats, super thanks, and donations via the website will go. It will go to the immediate help of this rabbit to get it off to a good life with us. And again, any extra that would be there, we will go ahead and forward to the Humane Society. So thank you in advance for anybody who chooses to do that. And Barbara, again, thank you for the $10 you've already done. I've talked enough. Let's go back to Judge Simpson.
All right, just try to make sure you do it within those windows. Okay. The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy though, right? So maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway, I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay. All right. Thank you. How are you, sir? Yes.
Thank you, Your Honor.
Court recalls the case People versus Reginald Sims.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Sims, present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. We believe it to be factually accurate. No additions, corrections, deletions. If I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think that I think you know what we need, what else we need to address.
Yeah.
If you prefer that we address the bond violations first.
We might need to. do
Okay.
that, but
Certainly.
either way, whatever. your pleasure.
Well, we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns that it looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single positive test since he's been testing, whether before this, after this, at any point in time. I think he's demonstrated that he takes the court's orders extremely serious, albeit with some hiccups here, but nevertheless stands before you taking accountability for those. Is intent on demonstrating to the court, as he's already done for himself and his family, that he's going to abstain from alcohol.
when I look at this though, I mean, it's a 3-hour window and I'm unclear as to why he can't get himself in that window on numerous occasions. I've got 1, 2, 3, 4, 5, 6, 7, 8 missed windows. I mean, in some, he's up to an hour late in terms of testing.
5 in the morning. There's 2 tests. There's 6 to 9 and 12.
Right.
Yeah, so it's 2 months.
Yeah, so, Your Honor, he's working 6 PM to 5 in the morning. So basically he gets home and it's testing windows about an hour later. So he's basically got to fight to stay awake. And then sometimes, again, it's no excuse, but he falls asleep. And so before that 6 AM window starts, he gets home at about 5:15, and he's basically got to fight it for 45 minutes to stay awake so that he could submit to it. Sometimes he misses that. And then the 12.
I get that, but there's only one of the tests that's a 6 AM test.
And then still,
12 to 3 is the next one.
and then the next one's 12 to 3. And then he's saying he sleeps during that, gets up at around 5 PM, gets ready for work and goes to work.
So I get that. So then why is he missing his 9 PM? His 9 PM test, which are 3 of these.
Your Honor, I know of one time I traveled and didn't get there to 12:07. Maybe it's something like a 12:04, 12:07. The other 2, I'm going to honestly say machine. I work, and I usually do that on my break. I'm at work at that during the 9 PM to midnight. So I've taken it every time, in my opinion. However, I did notice once or twice that it called for a late register. It said it did not, and I assumed or thought I did. So I do the thing all the time. Is, like I say, I work. I'm asleep during the 12 PM to 3, and I've missed that a few times because I just wake up 15, 20 minutes behind, so forth. But then I'm taking the test, Your Honor. I don't drink.
I mean, I hate to do this, but because if I get, I mean, the cold-hearted reality is that these are really violations of tether. May say there's no distinction between that and drinking, but certainly the court could treat it that way. Is a scram tether going to work better for him? Or
Honor,
30 days that he's going to be on something?
What do you want to say?
Your Honor, if I'm just saying, I'm also a coach, so there have been a few times where I was either with the kids or the parents, and I'm always trying to break away, and so I can do that. So there has been a few times where I'm in the midst of school administrative stuff because I got to blow up between the 12 to 3, and I try to get, and that you can see that they're just a few minutes behind. But I participate as a coach also at Belleville. I'm a coach and for 20 years, and so I am a part active as well as working. And I'm trying to make that time. There are only time.
Well, but you've got to make the time.
I have been.
Otherwise, what's going to end up happening is I'm either going to have to incarcerate you, or I'm going to put a scram tether on you, which in dealing with the kids, and I see that is going to be probably more problematic in terms of what you'd have to explain to them.
Your Honor, when you look at the report, it recommends basically giving him an audition here, 30 days, get it right, or he has no excuse. I think that that's fair and appropriate. I've impressed upon Mr. Sims the importance of showing the court 30 days without a single violation. I think we would respectfully request the court adopt that, give him an opportunity to prove that he's going to be intent on getting it done.
I just say there's a 3-hour window, and you just don't have to wait to the end of that 3 hours. You just have to do it within that 3-hour window. So in that respect, you really shouldn't be missing it. Okay, you just have to find time within that 3 hours to do that. All right, am I understood?
Understand.
Go ahead, Council, as to sentencing.
Well, I just briefly alluded to one of the points was that 30 days on the sober link. I think, again, based on everything we just discussed, I think that's fair and appropriate. We'd ask the court to adopt that. As it relates to the impact panel, we did tender proof of completion to probation, that has been completed as well. I understand that they are recommending in the alcohol education program. I think that given what I know about Mr. Sims, that would indicate that he can complete that program and move forward with this. Otherwise, we think that the report and recommendation is fair and appropriate. We'd ask the court to adopt it.
All right, sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. Once again, I've been a standing citizen. Not only did the court have to give me a penalty or to say I had to do the breathalyzer, I did not drink. I have not drunk since the day of my accident. I want to take responsibility of that. Due to leadership, I'm part of I lead kids around and coach and things like that. So I have to make an example for myself as well as others. So yeah, to tether things like that, yeah, I'm a good citizen. So I don't want to be explaining to these kids like, the breathing. Like I said, I had to run out and do those things. I couldn't do that openly, but doing positive things, staying active, and I just work, stay active with the children and spend time with my grandkids. So I follow your system. I believe. I apologize for the times that I was late. However, I was just late, based on activity and or sleep. But I respect the system. I apologize for being here, wasting everyone's time. And I'd like to move forward with you on good behalf.
Who's here with you?
My,
Who?
my missus.
Should say that louder.
I didn't.
You like whispered it, like.
Oh no, I didn't think
You didn't
so.
want anybody to know. I figured that was.
No,
who
no.
it was.
She's here.
Ma'am, you want him back?
Yes, but I'm tired of probably reminding.
Ah, see, I knew. That's why I wanted to talk to her, because she looked responsible. Like, you're talking about what a good and upstate citizen, and I'm not disputing that, but I think somebody helped you get there.
I sleep during that time period, Your Honor. So
Well, hold up.
12
Hold
to
up,
3.
hold up. See, why are you talking?
No.
She just told me that she's trying to remind you. She's sick and tired of having to remind you,
Understandable.
right?
Yes.
So, and all that really tells me is that at times, your husband is just not listening. She's trying to get you to do the right thing and follow all along. Am I right, ma'am? Yeah, okay. See, she's still trying to save you. All right. Listen to her.
I do.
She'll make sure that you'll get this done so you don't end up in trouble. You hear me?
Yes, sir.
I guess if she wants you back, I'm not going to stand in the way of that. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol. Tell them not to do that. Alcohol highway safety education program and abstinence from intoxicants for a year. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I'm going to place you on probation for a period of 12 months. An order $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that?
Within 30 to 45 days, Your Honor, I'll put that.
Pardon?
30 to 45 days. Months.
You ask the person in charge when you could pay it? Or are you just making that up?
I just know I'll put that.
Ma'am,
next
ma'am, ma'am, when can he get this paid? In a month.
the next month's budget.
Well, no, you know what? You just,
The boss has
you
spoken.
need to stop talking. I just went to the brain trust. I got it.
Okay.
In a month. So by January 30th?
Yes.
Thank you, ma'am. I would imagine every time you started thinking on your own. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Alcohol Highway Safety Education Program. You're to provide proof of the victim's impact panel attendance to probation. That has been completed. I'm going to continue the sober link for an additional 30 days in lieu of 5 days in jail. Order 93 days in jail suspended. Sir, one thing about me is I've got a very good memory. And your wife told me she's reminding you. So if I have a missed test, late test, anything like that, that means that you're not listening to her. I will use that jail time for that sole purpose.
Well, thank you, Judge Simpson, for cutting your feed right in the middle of that lovely lecture. Let's go ahead and go to Judge Mercer. But Michael, thank you for the $20. Bunny thanks you for that. It's very kind of you. Let's go to Judge Mercer.
Ms. Atkins, good morning. Ms. Atkins, you're here because you've been accused of it's like 8 total charges. 1 count of theft, retail theft between $100 and $750. 6 counts below $100 and 1 scheme to defraud. All of those are misdemeanors except that last charge. That scheme to defraud is a felony charge. I read the complaint. Again, there is probable cause for the charges, Ms. Atkins. I've also looked at your criminal history. You've got several prior charges. So you're probably gonna get a bond, but I'm gonna listen to the attorneys before I make a final decision. Mr. McDaniel, anything on behalf of Ms. Atkins?
Your Honor, we just asked the court to consider conditional release. I don't think she has much of a criminal history. She also is, has some medical issues. I think she's,
I'm going through another top. I'm sorry.
Can you let me?
Yeah,
so,
absolutely,
Your Honor,
sir.
I think she's, you know, maybe have a, deceased baby in her that they're trying to get out right now. So they're got surgery and stuff planned up the next few days for that, emergency surgeries for the baby and whatnot.
Okay. I'm sorry to hear that. Ms. Atkins, the criminal history I've got shows nothing in Florida, but in Indiana, I'm showing close to 10 arrests. Is that wrong?
I haven't been in trouble for almost 6-7 years.
You totally ignored the question. You've totally ignored the question. I'm showing about 10 arrests. Is that wrong?
I don't know if about 10, but yeah, I got like 6.
Last charge being 2020, false information and driving while license suspended. Is that the last time you've been in trouble?
Yes, sir.
Okay. 5 years ago. Mr. Mitchell, anything from the state?
Just a reasonable bond under the circumstances.
So, Ms. Atkins, I'm going to set you a bond. Your bond's going to be $5,000 on the felony, $1,000 each on your 7 misdemeanors. Your total bond is $12,000 cash or surety. I don't have a problem with a medical furlough if that's appropriate. So, Corporal, if the medical furlough is what we need to do in this situation, someone let me and Mr. McDaniel and Mr. Mitchell know the details. And if that needs to happen according to your medical staff there at the jail, obviously we'll need to try to make that happen if it's appropriate. So in the meantime, you've got a bond of $12,000 cash or surety. You do have a condition of absolutely no contact with any Walmart while this case is pending, Ms. Atkins, because of the type of charge you have. You will get to use the phone in just a few minutes, ma'am, and the medical staff should be seeing you sometime shortly. Ms. Atkins, do you have any questions?
No, sir.
As far as the court date, are we still on the January 6th cycle? The jail's gonna give you a notice for your court date. That'll be January 6th in circuit court, ma'am. That'd be at 8:30 a.m. Wish you the best.
And Your Honor, I
Thank
guess I
you.
will just state the state has no objection to a medical furlough. So
Thank you. All right, wish you the best, ma'am.
Thank you.
Yes, ma'am. Luis Sanabria Canas.
We don't have an interpreter here yet, so I'm going down to David.
Was there an interpreter request done? I haven't seen one.
I was told there was.
They're working on it right now. I just talked to them. They're working on getting one right now.
So was there an interpreter request done, Sergeant?
Yes. I did do one, but I forgot to email it. So that was just done in the last couple minutes, and I called
and spoke to them at the courthouse, so they're working on getting one right now.
Okay. Mr. Santa Briacanis, do you request the services of an interpreter? Do you speak English, sir?
This is David. They don't speak English.
Okay.
Neither.
This is David I'm sorry. How do you pronounce your last name, sir?
Prokopchuk.
Prokopchuk. It's not
Yes,
hard
sir.
when you do it slowly. Prokopchuk. Mr. Prokopchuk, you're here in case 25-501, and the charge is confusing because the charge as filed just says failure to pay civil fine. Yeah,
It's $105 fishing ticket, your officer. Your honor.
So hang on just a second before we get to that. My question, Don, is it appropriately set up? Why would it not say the charge? Why would it just say failure to pay fine? That doesn't seem like that makes.
Right. Yeah, it was
Just a second. I'm asking the clerk a question. Right. So what is the actual charge? No expired fishing license, and it was civil originally, but when you don't pay it, it becomes criminal. Okay, so that's what you're accused of, sir. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to David. He's going to plea of no contest. The charge is listed. The understanding that it'd be, he'll serve 4 days in county jail. He'll have credit for 4 days. He'll get out this morning. There'll be a $370 fine or whatever the court sets for a fine. And I advised him that he needs to make sure he makes that payment at the clerk's office within 60 days or set up a payment arrangement or they're going to suspend his license.
Well, considering the amount of time you spent in jail, I'm inclined to just impose the original fine, not the regular court costs and fines. What was the original fine amount?
105.
105?
Yes.
Mr. Mitchell, any objection to that?
No objection.
Sir, do you have any questions about that agreement?
No, sir. It's $105 will be the payment.
Right.
Yes, sir.
And what'll
Yes,
happen
sir.
is if you don't pay that, you can't go to jail for not paying it because you've already served the jail sentence, the criminal case is over. But if you don't pay it, your driver's license very well may be suspended. That's why you've got to pay it within 60 days.
Yes, sir. And it's $105.
Is it 60 or 90? Before y'all suspend a driver's license? It's 90 days before they suspend your driver's license. And yes, it's $105, the same amount earlier. I'm not adding the normal criminal court costs and fines because you spent this time in jail. Okay.
Yes.
I think everyone thought when we set the bond, we thought you'd post the bond and it'd be over with essentially, but that didn't work out in that manner. So is this the plea you would like to enter?
Yes, sir. Guilty. Yes, sir.
I want to accept your plea of plea of guilty then to the charge of no or expired fishing license, which became a criminal charge. I'm going to withhold adjudication of guilt. I'm going to sentence you to 4 days in jail, but give you credit for 4 days you've already served. It's a time served sentence. There are court costs and fines. There'll be court costs in the amount of $105. And as I've explained, the clerk's office will suspend your driver's license if you don't pay that under Florida statute. So, sir, what's going to happen is they're going to do a warrant check for you. I'm not aware of anything else. As long as you're not wanted anywhere else, you're going to be released this morning. Just take care of that within 90 days, or your license may be suspended. Do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Johnny Gore. Mr. Gore, good morning. Mr. Gore, you're here because you're wanted out of the state of Georgia. Mr. Gore, I believe you're just here to see if you want to sign a waiver of extradition. That may be what Mr. McDaniel's got there in front of you. All right. Mr. Gore, I see you just signed that. Do you have any questions about the waiver of extradition process?
I don't know, sir. Like,
Not about the case, but
my
about the waiver.
understanding, this is supposed to be over with, but I don't know what's going on.
Okay. Do you have any questions about the waiver of extradition process? That's what you're here for today. I'm not the judge in your case. I'm just deciding if you.
No, sir. I'm just trying to see how long they had to come get me.
Okay, so I want to make sure you're voluntarily waiving extradition. They have 30 days to pick you up under state laws. The two states work under the same law, but it's very rare for them to take that long. Mr. McDaniel, my sheet
Seminole County
didn't say what county in Georgia. What county? How far in Georgia? Up? How far north Georgia?
Seminole, so it should, they usually less than a week, but it is Christmas, so I mean, I don't know, it could be a week.
So Mr. Gore, with Seminole County, as Mr. McDaniel said, normally you're talking a few working days, but it is Christmas week. So if you're still here in 15 days, I'll see you again. That's very, very rare for you to still be here in 15 days. If you are, though, we'll see you, and I'll ask the jail what's the latest with the transport, and you'll get to hear that answer. There's a good chance you'll have already be gone before 15 days. There's a good chance you'll be up there this week. They'll be notified today to come pick you up now that you've signed the waiver in front of a judge. Do you have any questions?
No, sir.
All right, sir. Have a good day. Okay, so that's it, except for our two non-English speaking individuals. So all I know to do on those is I have nothing on an interpreter, and it could be a 5 minutes, it could be an hour. So all we can do on those cases is see them tomorrow. Who is this, Mr. McDaniel? Which case is
Oh,
this?
that's the two Hispanic ones, since you were talking about.
Okay. So do either of you speak English?
No.
Habla inglés? Okay.
A little. Poquito.
Okay. Habla un poco de español. Un poco.
Okay.
Pero, por favor, hable despacio. Despacio para que yo pueda entender. ¿Entiende?
Okay. Sí.
Okay, so I said I speak a little Spanish, a little, but please speak slowly so that I can understand. No interprete aquí today. ¿Entiende?
Sí.
Un momento, Judge. We might be able to bring.
Un momento, por favor.
If you want to do that.
Tendremos un interpreter aquí en un momento. Puede, possibly.
I would probably get Lawrence to see if he could give us his services again, but he's not here today. Yeah, they had the baby. Little Lawrence Jr.
Jake, or somebody want to ask Amber and see if like they got somebody coming right now, or if not, then.
Well,
I don't think the jail, if the jail does one 5 minutes before it starts, and our primary translator, Mr. Ricardo, is out on medical leave, it's almost impossible to get one set up that quick. So it's just, it happened too late to have it happen. So the only way it's going to work is if we have somebody in the courthouse who speaks a lot better Spanish than I do, which isn't a high bar, but it's
Stacy
still
not
there.
there today?
Mr. Goodson is here. How's your Spanish, Mr. Goodson?
no muy bien.
He says as a probation officer, he has perfected the phrase no cervezas, but that's about it.
I guess while we're waiting for him to get up, do you want to talk about the
Just a
two?
second. No, I don't. Take me just a second. So we do have an interpreter on the way. Okay. Tendremos un interpreter aquí en un momento. Entiendo? Okay. So while we're waiting, Mr. Mitchell, there are two cases set for this afternoon. Is that correct?
Yeah, it was
Let me get my calendar pulled up here and see what we got.
status conference for those old cases, old CT cases.
What time are they at?
They were set for 1:30 according to the email that Pamela sent me and Taylor.
Dawn? I'm only showing one on the calendar.
Is that our interpreter?
Yes, sir. Good morning. How are you, Judge?
Oh,
We let him, hey, good morning. We let him know that we've got an interpreter, please. Good morning, ma'am. Thank you, and apologize for the last minute notice. We had a mix up this morning. Can I get your name, please?
Yes, sir. No worries. Sarah Bear, Judge.
All right, Ms. Bear, thank you. My understanding is you're fluent in Albanian Swiss. Is that correct?
No, sir. I am fluent in Portuguese and Spanish. They told me it was for a Spanish interpreter.
It is for Spanish interpreter. I was just messing. I was just joking. So we have two individuals this morning. We have Luis Sanabria Canas y Sergio Quijada Mejia, excuse me. So let me start with Mr. Sanabria Canas. If you please introduce yourself to them in Spanish and make sure they can hear you, please, ma'am.
Yes, sir. Buenos días, señores. Yo voy a ser la intérprete para ustedes hoy. Creo que esta es una primera apariencia. Me llamo Sara y vamos a empezar.
Okay.
¿Me pueden oír bien?
Sí, sí.
Yes, they can hear me, Judge.
Mr. Sanabria Canas, we'll start with you.
Señor Sanabria, vamos a empezar contigo.
Okay. You're accused of one count of obstructing an officer without violence.
Tú estás acusado de un conto de, perdón, de impedir el policial sin violencia.
You have a bond that's already been set by a judge over the weekend.
Usted tiene una fianza que ya te fue puesta por un juez en este fin de semana que pasó.
Sí. And you're here today to be made an offer and also to have an attorney appointed if you ask for one.
Y hoy estás ahí presente, te van a hacer una oferta del Estado y también te van a presentar un abogado si necesitas uno.
Mr. McDaniel, are you indicating there's an agreement reached?
There is, Your Honor.
Preguntó si ya llegaron a un acuerdo, dijo que sí, que ya llegaron a un acuerdo.
Sí. I'm appointing the public defender's office to represent you. Please listen to your attorney.
Yo voy a apuntar un defensor público para poder ser a tu abogado. Por favor, hazle caso.
Okay. Your Honor, I've spoken to Lewis. He's going to enter a plea of no contest with the understanding he'll be sentenced to 60 days in jail, 2 days jail credit.
Señor, le expliqué a él que va a hacer un acuerdo con el Estado, que no va a contestar. And I'm so sorry, counsel, you said the plea was for how much jail time?
60 days with 2 credit.
Okay. Va a ser un acuerdo sin contesto y vas a pasar 60 días en la cárcel y te van a dar crédito de 2 días que ya serviste.
Okay.
Okay.
There'll be a $370 fine.
Tendrá una multa de $370.
He's waiving his right to a jury trial and call witnesses at that trial.
Él abrió mano de su derecho de tener un juzgamento con testimonios y con cualquier otro procedimiento.
He understands that any conviction can result in ICE deportation.
Y él también entiende que cualquier convicción que le pase puede resultar en el ser deportado.
That'll resolve this case this morning.
Y esto va a resolver este caso en particular esta mañana.
Okay. Mr. Mitchell, is that plea agreeable with the state?
It is, Your Honor.
Sí. Señor Mitchell, ¿el Estado está de acuerdo con esto? Sí, el Estado está de acuerdo.
Mr. Sanabria, did you hear that agreement?
Señor Sanabria, ¿usted oyó este acuerdo que hicieron?
Sí.
Yes.
Do you have any questions about that agreement?
¿Usted tiene alguna pregunta sobre este acuerdo?
No, está bien.
No, it's okay.
Is that the plea you would like to enter, sir?
Y es el testado que usted quiere hacer.
Sí, estoy confundido porque me pusieron 30 días de más a mí. Porque
Yeah, I'm
manejar.
confused because they told me it was 30 days because I was driving.
Offer made to you this morning based upon your prior history of 60 days in the Jackson County Jail.
Te recuerdo esta mañana que porque tiene un histórico anterior será 60 días en la cárcel del condado.
You appear to have prior criminal history in the United States. Mr. Quijada does not.
Porque tú tienes precedente criminal en los Estados Unidos. El otro señor no.
His offer is 30 days.
La oferta de él es de 30 días porque no tiene ningún histórico criminal en el país anterior, pero tú sí.
You do not have to take this offer. You can post the bond that's been set for you if you wish.
Usted no tiene que aceptar la oferta si no quiere. Si quiere postar la fianza y salir y ir a juicio, puede.
¿Puedo pagar mi fianza y salir?
I can pay my fine and leave.
You can post the bond, but the Immigration Service has a detainer placed on you, so you'll be released into their custody.
Usted sí puede pagar la fianza, pero la inmigración tiene una detención en tu contra. Entonces, aunque pague la fianza, te van a libertar, pero la custodia de la inmigración.
No importa, yo si me mandan para mi país me voy, pero yo no quiero estar así. Mis hijos me necesitan.
It doesn't matter to me. If I get deported and I have to go, then I go. My children need me.
I have no idea if you'll get deported or not. I'm only the judge in the resisting without violence case.
Yo no tengo ninguna idea si sí te van a deportar o no. Yo solo soy el juez en el caso que de esta resistencia al arresto sin violencia con el policial.
So
Yo
in
quiero
that
pagar mi
case,
fianza.
do you want, in that case, in the resisting case, do you want to post the bond or do you want to take the plea offer?
Entonces, en el caso, para resolver solo el problema o la cuestión de que resististe al arresto con el policía, ¿quieres pagar la fianza o quieres aceptar el
Sí,
acuerdo del Estado?
quiero pagar mi fianza.
Yes, I want to pay my bond.
Your bond is $3,500 cash or surety. Have a good day.
La fianza es $3,500, sea en dinero o con propiedades. Que tenga buen día.
Okay.
Mr. Quijada, you're here because you have the exact same charge.
Señor Fijada, estás aquí porque tienes el mismo cargo.
That is resisting an officer without violence.
Resististe a detención sin violencia.
I'm going to appoint the public defender's office to represent you this morning.
Yo voy a apuntar al Estado que te dé un defensor público esta mañana
And ask that you listen to your attorney, Mr. McDaniel.
y pedir que por favor hazle caso a tu abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Sergio, but let me ask him again.
Señor juez, había hablado con el señor Sergio, pero déjame preguntarle una vez más.
Do you want to post the $3,500 bond or do you want to accept the 30 days in jail?
¿Usted quiere pagar la fianza de $3,500 o quiere aceptar el 30 días en la cadena?
Yo quiero pagar la fianza, pero no tengo ningún número, no me acuerdo ni un número. Ellos agarraron el número de mi señora aquí, pero no me lo quieren dar.
I want to pay the bond, but I don't have anybody's phone number. They took my phone. I don't have my lady's number to call her.
If you choose the bond, you have the right to use the phone. I can't control what phone number you have access to.
Si tú eliges pagar la fianza, sí puedes hacer una llamada, pero yo no tengo control sobre cuál número usted tenga acceso o no.
So you have the bond set by the weekend judge. You will get to use the phone shortly.
Entonces te dieron el tanto de la fianza por el juez del fin de semana y vas a poder utilizar el teléfono en un rato.
Corporal, in both of these cases, we need to give them a notice for their January court date.
Y en los dos casos le dimos una noticia del día de la corte en enero.
January 6th at 9 a.m. will be their court date.
El día 6 de enero a las 9 de la mañana va a ser el próximo día que tenga que presentarse perante la corte.
Have a good day, Mr. Chiara.
Tenga un buen día, señor Chiara.
Gracias.
Thank you.
Thank you. Madam Interpreter, thank you very much, ma'am.
My pleasure, Judge. Happy holidays to you.
Same to you. All right, Mr. McDaniel, that's it as far as I know. Anything else from the Public Defender's Office this morning?
No, Your Honor.
Corporal, anything else from the jail?
No, sir.
And Mr. Mitchell from the state?
Other than those two status cases to talk about, that's nothing else from the state.
Thank you. So, ladies and gentlemen, that concludes first appearances this morning. Thank you, Mr. McDaniel.
All right, that brings to a conclusion our time with Wade Mercer today. Always a good time. Let's go back up to Michigan, though. We'll say good morning to Judge Middleton.
Your Honor.
Yes, thank you, Vivian.
Thank you. Have a good day. Merry Christmas.
Thank you, you too. Hopefully that's all we'll need today. Thanks. Good morning, sir. Are you Donnie Buchanan?
Yes, I am, sir.
Welcome to Centerville. You got a ticket on December 1st for driving without insurance. You get lots and lots of these. Wow. Vivian, Laura, I'm out of register of actions. How did that happen? Anyway, no insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000, excuse me, up to $500. Carries not less than $200 fine plus cost. I ask everybody the same question. Do you have insurance now?
Yes, I do, Your Honor.
Do you have proof with you?
Yes, I do.
Who's your carrier?
State Farm.
All right. We have some pretrials this morning that the prosecutor is doing. I'm gonna see if I can get them to do a pretrial on this, yes?
I made a note. I've already talked to Prosecutor
Okay.
Gary. He is offering the civil infraction.
Oh, good. Who'd you talk to?
Gary.
Thank you, Gary. He seems to be the only one that comes in early. Thank you very much, Gary. We get lots of these, as in dozens or hundreds. Probably by the end of the year, we'll have several hundred of these. It's a heavy-duty charge. It's under the insurance code rather than the motor vehicle code. The minimum fine is $325. It's a misdemeanor punishable by up to a year in jail, and it requires that you get fingerprinted. About 80% of the time, the people are like you. They come in and now show that they have insurance. What the prosecutor will do with those is dismiss the original charge and turn it into a civil infraction known as no proof of insurance. That means you didn't have the slip in the car. That carries a fine of $150. It's not a crime, it's a civil infraction. And it doesn't carry as much damage to your car insurance. Are you willing to plead to that lesser charge of no proof of insurance?
Yes, I am, Your Honor.
All right, very good. In fact, when you plead to that, you don't even, it's not a guilty plea because it's not a crime. You admit. State Farm. They can now run your plate and see whether you have insurance. Laura, I'm running out of envelopes too. And so they pull people over by the dozens who are driving around with no insurance. It's very expensive if you get in a car accident with no insurance because you're not covered by the no fault statute. It also kills your insurance rates. Anyway, on that day, December 1st, did you not have proof that in the car that you had insurance?
No, I did not, Your Honor.
All right, the fine is $150. I'm gonna make that due by February 1st, 26. That's much less onerous than 325. 252494 SM. You can use a credit card to pay this, send in a certified check or money order, or bring in green cash.
Okay.
But you're good to go.
All right, thank you.
All right, thank you. I'm glad you're insured. Thank you. Oh, Abigail? All right. Year end, running on everything. All right, we're plugging away. I don't see Michael Blasius. Oh, the other Michael Blasius. Okay, come on up. Your dad and I go back a long way, and I was hoping it wasn't him, but unfortunately it's you. This is file 252336. We go back a long way.
Yes, sir.
You got a ticket on 11/12 at 5:56 a.m. at 131 on Lovers Lane for driving suspended. What 5:56 a.m. tells me is that you were on your way to work. Your license is suspended. For a bunch of stuff. Boy, you've had a bunch of accidents. Non-alcohol accidents.
Yes, sir.
But they suspended your license in 24. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 2 points on your driving record and requires that your license be further suspended. How do you plead to that charge?
Not guilty.
All right, you want me to appoint a lawyer to help you with this?
Yes, sir.
You have 6 points on your license. Now, this was November 12th. There was apparently an accident. You had another accident on October 23rd in Kalamazoo. Another accident in Kalamazoo in July. And a driving suspended here last January. And another accident in Kalamazoo in 23. Wow, another accident here in 23. How many accidents you been in?
Yes, sir, Your Honor.
About 10. 22 crash. 80 and a 70. 18 crash. Holy smokes. All right. There was an accident this day?
Just went in a ditch.
All right.
No two-car collision or anything.
All right. Appoint an attorney. How'd you get here?
My brother-in-law.
All right. Set attorney pretrial for February 6th. At 8:30. I don't think you owe us any money.
I owe back restitution, but I pay on it every month.
Do you?
Yes, sir.
All right. Well, this wasn't good. I'm guessing at 6 o'clock in the morning you were going to work, but I don't know that. But you were supposed to be driving. You keep crashing, so the state took your license away. All right, you go out, we'll get a lawyer to help you with this.
Thank you.
All right, good luck, sir.
Thank you.
Tell your dad I'm glad it wasn't him. Sorry it was you, but I'm glad it wasn't him. All right. Matthew Samansky. Good morning, sir.
Good morning, Your Honor. You did very well with the last name, I must admit.
What?
You did very well with the last name.
All right, well, good. I mess a lot of names up. The names are important. 2523888 SM. You got charged also with no insurance.
That is correct, Your
Do
Honor.
you have insurance now?
I do.
Ms. Jackson, did you get a chance to talk to anybody on this?
Yes, I talked to him at the same time. He has the same offer for civil infraction.
Very good. Thank you, Ms. Jackson. I greatly appreciate that. And thank you to Mr. Gabry for dealing with these. I had that nightmare day when I had to have 7 people all come back. Who's your carrier?
It's Progressive, Your Honor.
Were you driving a car on November 19th and you didn't have the valid slip in your car?
That is correct, Your Honor.
But you do have it now.
Yes, Your Honor.
All right, as you heard me tell the last guy, this is $150 as opposed to $325. Fine and cost is $150, and that is due by February 1st. Can you pay it by then?
By then, yes, Your Honor.
All right, if you need more time, come see us, but this is a civil infraction, not a crime. There's instructions in here on how to pay by online. All right, you're good to go.
Thank you, Your Honor.
Good luck, sir. And if you keep your insurance on there, you won't have to come see me anymore.
That's the plan, Your Honor.
All right, good. That's a good plan.
Okay, I've got my eyes on a bunch of different courtrooms around the country. It's a bit of a mixed bag today, as you would expect on a holiday week. There's some courts that are running, some courts that aren't. Kind of what I expected. Let's change it up a little bit, though. We'll stay in Michigan, but let's say good morning to Judge Elmore. I think he's going to do a sentencing.
Petrie, am I saying that right? Yes, sir. Thank you. This is file number 25-14151FH. Appearances from counsel, please.
Joanna Carey for the people.
Allison Cass on behalf of Mr. Petrie.
Thank you.
Honor Lisa Kushitawa, always also on behalf of Mr. Petrie.
Thank you. Mr. Petrie is here in person, and also here in person is the agent from the Department of Corrections who prepared today's pre-sentence investigation report, Mr. Stephen Saladay. We are here today for a sentencing in this case. The defendant entered a plea back on November 24th to a single count of use of methamphetamine as a second or subsequent offender. Let me take a quick look here at the PSI. Any notes on it? That's pretty rare. Must not have seen it. One moment. All right, Ms. Carey, did you receive it? And if so, did you have any amendments, corrections, or objections to make?
Thank you. I did receive and review it. I don't have any corrections or additions. Thank you.
All right, same question for whichever one of the two is going to talk on behalf of the defendant.
Yes, briefly, to clarify, in one point of the PSI, it stated the recommendation was to 18 months, and another it was to a year and 8 months. And then the third section, it was to 18 months. So I'd be asking for clarification on probations.
Yeah, no problem. I assume, Mr. Saladay, you meant on CFJ 145, page 2, that would be 6 months.
Yeah, it should be 18 months, bro. Yes.
Yeah,
Yes.
1 year and 6 months.
Correct.
All right, we got that one. Okay.
And next being
Anything else?
yes, looking at page 9, looking at the employment section, prior to his drug use, Mr. Petrie advised that he was working 4 jobs from 2014 to approximately 2016.
Good. All right. And do you want to provide me any other detail there? You said
I would
from-
defer to Mr. Petrie.
All right, Mr. Petrie, it sounds like you had some other employment Right now, it's got listed as Northern Staffing.
Yeah, I did the last 10 years only. I didn't do like anything at all that. I worked at Pompey's and Baldwin since 2006 to 2018.
Okay, hold on. Pompey's, that's a pizza place?
Yes.
And that was 2014 to
2006 to 2018.
I'm sorry, I misunderstood you.
Sorry.
2018, copy that.
And then to Reed City Pompey's 2011 to 2013.
2011 to 2013?
Yep.
Okay, so you worked at two different places, in the same business.
Yeah, same business. And then the Everett one, I helped establish the Everett one, Everett one too.
And when was that?
In between, like, so probably 2012 to 2014.
All right, we can add those, and it sounds like they're overlapping, and obviously it's all good for the same kind of business. Did you get all that, Mr. Saladin?
Yeah.
All right, thank you. Back to you, Ms. Castle.
And then just to clarify regarding his substance use as that is the offense he's being sentenced on today. His THC use, he advised that he quit using that altogether in 2013 when his son was 2 years old. That's what caused him to become sober from marijuana.
Okay, all right, we can go ahead and make that change. Thank you. Hold on, let me double check to make sure that not only are we talking on CFJ 145, page 1, but also in CFJ 284, and that would be page 10. Yeah, so we'll have to change that also on page 10. All right. That Mr. Saladin?
I do.
Next, Ms. Castle.
And yes, that is it.
Thank you very much. Give me just a moment to refresh my recollection. All right, Ms. Castle, allocation.
Thank you. We would be asking that the court adopt the recommendation put forth by probation. However, without him being sentenced to jail for the remainder of the term, he's been in custody for 57 days. Mr. Petrie was accepted into a 30-day residential treatment program addressing his substance abuse issues. When he was arrested for this event, he was experiencing a relapse. Prior to being arrested, he was successfully sober for 9 months. He had gone through treatment at Harbor Hall, as the report notes. However, he did leave early. His reason for doing so was that he was confident in his sobriety without it, and that he missed his son. And now what's changed is he's ready to move forward. He's ready, knowing that he can't do this by himself. He's explained to me that he understands the significance of community that he had when he was actively engaging in treatment, and he desperately wants that. He wants to get back to working the way that he was prior to his substance abuse taking off. He wants to be the father that his son deserves, and he's asking that the court give him that chance by ordering him to treatment, as well as the term of probation to keep him accountable.
All right, thank you. Ms. Carey, on behalf of the people.
Thank you. I am somewhat reluctant, but I'm going to ask the court also to follow the recommendation. And when I say I'm reluctant, it's because you look at the PSI, it says he's had very little work history over the last couple of years. He has mental health conditions that are currently untreated, and a long history of substance abuse, and the fact that he left Harbor Hall already before he completed is troubling. And I understand that now he knows he can't do it on his own. I hope that's true, and I hope he can show that moving forward. However, his history is not terrific, but I understand the guidelines, and I understand what the plea agreement was in this case and the reasons for that. So I am gonna ask the court to do the jail sentence with probation. Thank you.
All right, thank you. Mr. Petrie, I want to find out an answer to a question before I turn it over to you. 1 second, please. There it is. Mr. Petrie, I want to ask this question. I want to make sure it says, I know you have a son. Do you just have the one son?
Yes.
All right, I just want to make sure we're talking about the same. And do you have, what's your custodial relationship with your
I
son?
have full custody of my son. My sister has temporary power of attorney right now.
All right. How long have you had that full?
Since he was 3 years old.
All right. All right, sir, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say?
Yeah, if I'm able to go and leave to rehab, I'm like, my lawyer said, I'm very serious about it. I'm gonna seek transitional housing and stuff after the fact. Regardless on what happens here today, I'm still gonna go to rehab.
Mr. Saladay, are you aware of this rehab and have you confirmed it or don't know anything about it?
First time I've heard of it.
All right.
He expressed
Excuse me, Your
an
Honor.
interest in it.
Oh, yep, hold on.
He expressed an interest in it, but nothing had been set up at the time of the PSI interview, which was about 5 weeks.
Your Honor, I just want to confirm that you received the letter from the facility that was sent to your court and sent to send to the prosecutor.
When was it sent?
I spoke to them on Friday. We were, they confirmed that it was sent to the court as well as the prosecutor's office. They sent it to us by fax on November 19th.
Yeah, we'll take just a brief recess in place. I don't have it. I'll go check my office.
Okay, well, we wait for him to come back. Let's go back to Judge Middleton. And he is doing absolutely nothing exciting, but that's okay because Judge Elmore just got back.
I do not have any letter. Ms. Carey, did you get one in your email?
No.
Yeah, all right. Okay. All right, well, one moment. I'm going to get back to what I was reviewing a moment ago. All right. Well, let's take a look here. I look here at the agent's description of offense. Oh, by the way, Mr. Saladay, in the middle, at CFJ 284, page 2, in the middle of the large paragraph underneath description of the offense, on the 6th line down, 2/3 of the way through, it's got a misspelling. I assume that means he.
Yes, Your Honor.
All right, no problem. And this is the case where Mr. Petrie identified himself as a Daniel Howell, correct? Yeah, so and I know that was already acknowledged in the scoring of the guidelines, specifically offense variable number 19. One moment. Then,
No,
yeah.
Your Honor, that's wrong, I'm sorry.
Yeah?
How
Right.
was another person in the vehicle?
Okay, all right.
He just didn't provide his identification
Okay.
or name up front, and they had to take a picture of him to identify him at the shelter.
All right, so that is how, not he.
Right.
All right, good. I just wanted to make sure we got that right. See, when my pointers, there's multiple people in the vehicle. And when I look at the agent's description of the offense, got in the vehicle without knowing an individual fully. And then I relapsed. It looks to me like Mr. Petrie was already putting himself in a bad position by getting into this vehicle with people who clearly were lying parked behind a church. I don't know what he thought he was getting himself into. And it's not like he just relapsed there in the car. I mean, clearly he put himself in his position, or I think a reasonable person, or at least a reasonable person in his position would know he was likely not in the right place. One moment. And I recall reading this last week. 1 second. At the bottom of CFJ 284, page 3, this is Mr. Petrie saying that he just gotten a job, had a backpack, and then inside he had a magnetic case. And the cards with the syringes. To me, it sounds like he brought the meth to the car.
Yeah.
No? All right. Well, take a look here at the defendant's criminal history. It began in 2005, although relatively minor, no operator or no license on his person. He had a pretty good year, 6-year gap or so until he picked up another charge. Not that big of a deal, but it does have to do with the crime of dishonesty, having welfare fraud. He then made it about 8 years, but that case was dismissed. So actuality, he made it 9 years until 2020, where he was picked up while on bond and picked up another crime of dishonesty involving an embezzlement. And then while that case was pending, literally 2 weeks later, while still on bond, he picks up yet another charge, and that's for meth. And then he makes it 9 months before he picks up operating without his insurance and an unregistered vehicle. Not a big deal, but that means that the defendant here, knowing that he apparently has just gotten out of jail, he will do what he wants if he thinks he can't get caught sometimes. And then we have a gap in time from May of 2022 until January of 2023, so about 8 months. And then while in this case, he picks up a drug case, he absconds on probation twice. Well, he was supposed to do probation for 2 years, and looks like he only made it a year because he was in an absconder status. And then after that case, he made it a year until he picked up this case. And I appreciate Mr. Petrie, the interest in your son, but your son's 14. Your son was there when you picked up this case. Your son was there in your life when you picked up the drug case in 2023. Your son was there in the case just before that, the one before that, where you picked up another drug case. And your son was there for you when you were convicted of embezzling or stealing from a vulnerable adult. So what's different today? That's my key question.
What's different from today than, or from different today than then is that, you know, in retrospect, I messed up, I get that, but, I'm ready to do it for me. And I was just trying to do it for selfish reasons, and I was living life for me. I was trying to do this for me, I'm tired of living this lifestyle. That's what it falls down to.
I mean, you had just gotten out of rehab 6 months before. But you didn't complete the program because you left it.
I got my 30-day check though for doing what I was supposed to do.
Okay, all right. I'm glad to hear that. But you left the treatment program without completing it. And that's the only time you've taken a treatment program, at least according to the pre-sentence investigation report.
Yeah, at the time, like I said, like Ms. Castle said, that I felt as if I was trying to do it without that kind of stuff. But like the mechanic there was just not my style, I guess.
Yeah, I hear that one. The mechanic.
Yeah, like there's a ranking system, and it's very cultish.
At the treatment program.
Yeah, the treatment program.
Yeah. Well, that wasn't a court, was that a court order program?
No, that one in court.
All right. Now, we don't need to talk about all these in detail here, but in this report, I see that there are some health problems that you've got. And I don't see any medication or treatment issues.
I just like when I was at Harvard Hall, the therapist or whatever you want to call him, he diagnosed me with those issues.
Yeah.
Every time I went to CMH right after that, right after I left Harvard Hall, to try to get some help for it, and they told me I was very functional, that I didn't need it.
All right. Well,
I was in Osceola County.
Okay. All right. Well, here's the sentence of the court. First of all,
Excuse me, Your Honor.
Yep.
I located the facts from the treatment facility. Would the court like me to forward it right now?
Yes, you may, but I know what I'm going to do though. I mean, I'm going to allow him to get into the treatment program, but it's going to be set up and run through probation because I need probation to order him into the program, because that way if you leave the program, then that's a violation. And then if you leave it, you're gone for more than a certain number of days, which is 60, then that becomes a non-technical violation. And non-technical violations gives a lot more discretion what to do. So I'm just going to ask Ms. Satawa to go ahead and send it to us, and she can email it to the court. Make sure it gets to Mr. Saladay, and Mr. Saladay can confirm it and get him into the program. Did it have a start date, Ms. Satawa?
Oh, let me pull it right back up. It is dated November 19th. It says, to whom it may concern, this letter is to confirm that Cody Petrie, his date of birth, has been approved at Addiction Treatment Services 30-day men's residential treatment program. I'm going to mispronounce this word, but Dukoski Hall, that has an address in Traverse City. It does not have a start date.
All right, you got it right. All right, so here's what the sentence of the court is today. The court sentences the defendant to a period of probation for, I'm going to say 24 months. The court adopts the terms and conditions for probation that are listed inside the PSI and CFJ 145 pages 2 and 3. I find that those terms and conditions are well suited for rehabilitative purposes based upon the defendant's history involving controlled substances and other substances such as alcohol and marijuana. I thought alcohol was listed on it. No, it wasn't listed on there, but still a variety of controlled substances. And therefore, if a person's going to abuse one, I'm concerned that they might abuse another one. So therefore, that applies to alcohol and recreational marijuana. The court to sentence the defendant to a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. We have DNA here. I don't remember if he had a prior felony.
No DNA fee.
Yep. A supervision fee of $30 a month or $60 a month if there is any electronic monitoring. The court acknowledges that this is a intermediate sanctioned cell. However, the court does find reasonable grounds for some period of jail, specifically the times where he has been where he has violated bond, where he has absconded from probation, and that we have repetitive repetitive controlled substance cases, including, I think at least 2 of them were methamphetamine. So the court sentences the defendant to 90 days with 57 days of credit. And the court's going to ask the probation office and tell them, if you can get him into treatment ASAP, then we'll release you early to get you into the treatment program, okay? Now, you want to make sure you complete that program. You want to make sure that you invest all of your time in it. You do not want to leave early. If you leave early because you don't like the way someone smells, looks, or smiles, I do not care. All right, you've got to do the program. Have I missed anything, Mr. Saladay?
No, Your Honor.
Ms. Carey?
No, thank you.
Fence team?
No, Your Honor.
All right, thank you very much. All right, 1 second here. Oh, I find that the sentence is reasonably proportional based upon the factors I discussed and the contents of the pre-sentence investigation report. 1 moment. Samantha, are you going to run this over to him? One of you? I'm bringing out you 2 copies of 1 document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you have there with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. You have the right to be considered for early release from your probation at halftime. So if you have been compliant after a year, then you have the right to be released from your probation early. All fines and costs are due within 56 days, or the court can add a 20% penalty. That penalty can be removed by the court as long as you make payments by the end of your probation. So if you want to be off of probation early, you got to pay them early. Does it make sense?
Mr. Chairman,
All right. Mr. Petrie, how old are you?
I am 40.
Yeah, 40. You're old enough to know. You got a kid. I guarantee you he knows what's going on. Obviously, he knows what's going on with you and your life and your choices. It's about time to set an example, because if you don't, I hate to see him up in a court doing the same stuff. Kids pay attention and learn from their parents, okay? And let's hope that you can teach your son how to handle this issue and how to overcome it, okay? If not, I hate to think of it, but he will end up here in court someday too, okay? So don't beat yourself up for that part. Only beat yourself up if you ever go back and start using it again, because then, away. All right. All right. Good luck to you, Mr. Petrie. Thank you all very much. We are adjourned.
All right, let's change it up a little bit. Let's go to Fancy Court and say good morning to Judge Collada.
A sister that he's close to in the Cleveland area. That is how he ended up here from Florida. You know, Mr. Jones has always been, I know he's had some issues in the jail and in his past, but he has always been polite and respectful with me. I know it indicates in the PSR that he didn't really want to do probation or might not show up. He has told me that he absolutely would show up if he was given a community control sanction. I do also think that he could benefit from some sort of mental health treatment and something, maybe some services to help him get himself together out here in the community. Mr. Jones is remorseful that this occurred. I will say that while this is a burglary, a felony of the 3rd degree, it's not really your traditional burglary. It happened in a hotel, and there was one abandoned room that had things in it, and then this was another room that had things in it, but the door didn't quite shut or lock. There was something with the door where it just opened. So it's not like he had to bust the lock and break in that way or anything like that. He simply just pushed the door open and walked in. So it is a less serious form of the offense, Your Honor. And I would just ask you to take that into account when imposing a sentence. Thank you, Your Honor.
Thank you. Mr. Jones, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
No, sir.
Ms. Hibbert, anything else?
No, thank you, Your Honor.
Ms. Alessi?
Thank you, Your Honor. Pursuant to the plea agreement in this case, the state did agree to recommend community control sanctions. We felt at that time the defendant could benefit from mental health treatment and drug and alcohol treatment. As of today, the defendant has 106 days of jail time credit, and the victim did not request any restitution here.
This court has considered the pre-sentence report and investigation, the psychological evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here today by Ms. Hibbert, prosecutor. Defendant was given a chance to speak, chose not to make a statement, which is fine. All this is considered by the court. Oh, I also received a victim impact statement, and I've read and taken that into consideration. All this is considered by the purposes and principles of felony sentencing set forth in 29-29-11, which are the factors in 29-29-12. Victim suffered psychological and emotional trauma as a result of this conduct. I don't believe anything makes it less serious. This is where the victim was living at the time. It was a hotel. The defendant broke into the place where the victim was living and took his items. So I don't think anything is more or less serious in that regard. For recidivism factors, the defendant has a history of juvenile delinquency adjudications as well as convictions as an adult. He has failed in the past to comply with previously imposed sanctions ordered by courts. He's been on probation before in the past. He's violated his probation multiple times before in the past. There's absolutely no remorse. The defendant denies, first of all, committing the offense, denies taking anything when he met with the probation department. There's been no showing of remorse here. So it wasn't during the pre-PSR, it wasn't here. There's no remorse, let alone any genuine remorse. Defendant has indicated to the probation department that he doesn't want to be on probation. He's not going to report it. He's not going to be able to do it. He doesn't want to do it. These are all factors indicating recidivism is more likely. Nothing makes it less likely. It's a felony of the 3rd degree. There's no presumption either way. Prison is consistent with the purposes and principles of sentencing. There's just no way this court can make any finding that the defendant's amenable. He said himself he's not. Therefore, it's a sentence of this court that the defendant served a term in prison of 12 months. He has credit for 106 days he served. I need to advise you upon your release from prison, you'll be placed on post-release control for at least 1 year. Could be up to 3 years. While on post-release control, if you violate any of the conditions of your post-release control, the parole authority can send you back to prison as punishment for violating their rules for another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. Defendant's ordered to pay all costs incurred in this action. Is there anything else for the record, Ms. Alessi?
No, Your Honor, thank you.
Ms. Hibbert?
No, thank you, Your Honor.
All rise.
Fairly short and sweet from Judge Collada. Things are usually a little more drawn out there. Guess he's in a hurry to get to Christmas. Let's, haven't gone here in a while. Let's go to Lubbock, Texas, and their jail magistrate court.
Ms. Arredondo, you're here today to enter a plea. We're handling your plea over this Zoom proceeding. Is that all right with you for us to handle your plea over this Zoom?
Yes, Your Honor. Yes, Your Honor.
Fingerprints were taken from you there at the facility for us to use as your signature on your paperwork today. Is that okay with you for us to use your fingerprint as your signature?
Yes, Your Honor.
And have you been able to go over all of your paperwork prior to court with your attorney, Ms. Hillstrom?
Yes, Your Honor.
And did you understand everything and sign everything with your fingerprint freely and voluntarily?
Yes, Your Honor.
Now, in the county court 2025 criminal case 2223, you're charged with a Class A misdemeanor offense. And do you understand the full range of punishment that you're facing?
Yes, Your Honor.
And there's been a plea offer that was made to you today. Other than that offer, has anyone promised you anything for you to enter any type of plea today?
No.
And Ms. Hillstrom, do you feel like that your client understands her rights and the proceedings as well as her charges?
Yes, Your Honor.
All right, then Ms. Arredondo, in this county court case ending in 2223, you're charged with a Class A misdemeanor offense of false alarm or report committed back on June 17th of 2025. And how do you plead to that charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you have made today, and I will now assess your punishment in this matter at 60 days in the Lubbock County Detention Center with your court costs of $325. You're going to receive all of the jail credit that you do have in your case towards your sentence. Your jail credit is showing to be a total of 62 days from October 22nd, 2025 to the present time. And does that sound like your correct jail credit?
Yes, Your Honor.
Okay. Now your jail time and your court costs are running concurrent with each other as permitted by law. So you are getting jail credit towards those court costs that you're owing. And you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. And then having said all that, that makes this a time served matter in that case. Was that your understanding, ma'am?
Yes, ma'am.
Okay, and then as part of the agreement in your case today, I'm signing a dismissal of County Court 2025 criminal case 2222. And with that dismissal, does that resolve everything that your client has pending at this time to your knowledge, Ms. Hillstrom?
Yes, Judge.
Okay. Anything else from the state?
No, Your Honor.
Anything else, Ms. Hillstrom, in this case?
Nothing further, Your Honor.
All right, then Ms. Arredondo, jail staff will get you released later today once they're able to process my paperwork there at the facility. And you are adjourned and may leave the courtroom at this time.
Thank you, Judge. Thank you.
Thank you. Have a happy holiday. Lacey Jordan, you're next. Ms. Jordan, you're here today to enter a plea. We're handling your plea over this Zoom proceeding. Is that okay with you for us to handle your plea over this Zoom?
Yes, Your Honor.
And some fingerprints were taken from you there at the facility for us to use as a signature on your paperwork today. Is that okay with you for us to use your fingerprints as your signatures?
Yes, ma'am.
And have you been able to go over all of your paperwork prior to court with your attorney, Ms. Hillstrom?
Yes, I have.
And did you understand everything and sign everything with your fingerprint freely and voluntarily?
Yes, I did, Your Honor.
Okay. Now in this county court 2025 criminal case 2929, you're charged with a Class A misdemeanor offense. And do you understand the full range of punishment that you're facing?
Yes, ma'am, I do.
And there was the plea offer that was made to you. Other than the offer, has anyone promised you anything in order for you to enter any type of plea today?
No, ma'am, they haven't.
And Ms. Hillstrom, do you feel like that Ms. Jordan understands her rights in the proceedings as well as her charges?
Yes, Your Honor.
All right, then Ms. Jordan, in this county court case ending in 2929, you're charged with a Class A resisting arrest, search, or transport committed back on November 20th of 2025. And how do you plead to that charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you've made today, and I will now assess your punishment in this matter at 33 days in the Lubbock County Detention Center with your court costs of $280. You're going to receive all of the jail credit that you do have in your case towards your sentence. Your jail credit is showing to be a total of 33 days from November 20th of 2025 to the present time. And does that sound like your correct jail credit?
Yes, ma'am, it does.
Okay, so your jail time and your court costs are running concurrent with each other as permitted by law. So you are getting jail credit towards those court costs, and you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. So having said all that in your case, that means that matter is time served. Is that your understanding?
Yes, ma'am, it is.
Okay. And does this resolve everything that your client has pending at this time to your knowledge, Ms. Hillstrom?
It does, Your Honor.
And is there anything further from the state?
No, Your Honor.
Anything else in this case, Ms. Hillstrom?
Nothing further, Judge.
All right, then we will be adjourned in this matter. Ms. Jordan, jail staff will get you released later today once they're able to process my paperwork there. And you are adjourned from the courtroom. Thank you for your attention.
Yeah.
Shannon Garcia is next. And Ms.
May I-
Hillstrom, you're adjourned. Have a good holiday.
You too. Merry Christmas, Judge.
Ms. Garcia, you're here today to enter a plea. We're handling your plea over this Zoom proceeding. Is that okay with you for us to handle your plea over this Zoom?
Your Honor.
Some fingerprints were taken from you there at the facility for us to use as your signature on your paperwork today. Is that okay with you for us to use your fingerprints as your signatures?
Yes, ma'am.
And have you been able to go over all of your paperwork prior to court with your attorney, Mr. Lamont?
Yes, Your Honor.
And did you understand everything and sign everything today freely and voluntarily?
Ma'am.
Okay. Now in this county court 2025 criminal case 2071, you are charged with a Class A assault domestic violence. And do you understand the full range of punishment that you're facing in this case?
Yes, Your Honor.
And there was a plea offer that was made to you. Other than the offer, has anyone promised you anything in order for you to enter any type of plea today? This is an assault domestic violence charge, and if you do plead guilty to this and you are convicted, if you were to commit another assault domestic violence in your future, this state or another state is going to be able to use this conviction from today in any future case of assault domestic violence in order to make the punishment worse on that future crime. It would be used as what's called an enhancement provision. Do you understand that? Okay. Also certain, this is one of those types of cases that will negatively impact your ability to purchase or possess any firearms, weapons, or ammunition of any kind in the future. And do you understand that as well?
Yes, ma'am.
Okay. And Mr. Lamont, do you feel like that Ms. Garcia understands her rights in the proceedings as well as her charges?
Yes, Your Honor. And in relation to the affirmative finding of family violence, I specifically went down this morning and provided her detailed information along with a summary of that information and answered any questions that she had. So I do believe she is fully informed and ready to move forward.
Okay, great. Thank you. So Ms. Garcia, back to you. In this county court case ending in 2071, You are charged with a Class A assault domestic violence committed back on August 19th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you've made today, and I will now assess your punishment in this matter at 119 days in the Lubbock County Detention Center with your court costs of $350. You are going to receive all of the jail credit that you have in your case towards your sentence. That is showing to be a total of 119 days from August 19th through September 18th of 2025, and then September 26th of 2025 to the present time. And does that sound like your correct jail credit?
Yes, ma'am.
Okay. Now your jail time and your court costs are running concurrent with each other as permitted by law. So you are receiving jail credit towards those court costs that you're owing, and you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when Mr. Lamond was appointed to represent you. And having said all that, that makes this a time served matter. Was that your understanding, ma'am?
Yes, Your Honor.
Okay. And does this resolve everything that your client has pending here in Lubbock to your knowledge, Mr. Lamond?
Yes, Your Honor.
And is there anything further from the state?
No, Your Honor.
Anything else, Mr. Lamond?
No, Your Honor.
All right, then we will be adjourned in this matter. Ms. Garcia, you're adjourned from the courtroom. Jail staff will get you released later once they're able to process your paperwork there. Have a good holiday.
Thank you, Your Honor.
Thank you. And Mr. Lamond, you're adjourned unless you need something else from the court.
Thank you so much. Have a great day.
Thank
Happy
you.
holidays.
All right, let's switch it up a little bit. Let's go to, why is my phone ringing? Let's go to Judge Oakley. Let's see what's going on with him today.
Have a seat, people.
I knew a guy that was a truck driver, kept going to chiropractor, so bad guy, he was a chiropractor, someone told me, quit sitting on your lawn.
Oh, yes.
His wallet was like that thin.
It's like, what an idiot. How come he couldn't figure that out?
Exactly.
He could stop fighting me. Where'd you go?
I thought you had a paper train. Thomas Makarowski. Good morning, Mr. Bowditch.
Good morning, Record Jeffrey Valley, 45367, appearing on behalf of Tomkowski. Sir, could you tell your name for the record, please?
Good morning.
Your Honor, today's date, time set for breaking in this matter. We waived former reasons. Also had a chance to pre-try this case. You have an executed plea agreement subject to court approval. In that agreement, Mr. Tomkowski, when you plead guilty to an added, all visibly impaired, understanding and approving the charge with previous means.
Thank you. Sir, did you discuss your rights and options with Mr. Bowditch today? You understand your, those options you're presented with?
Yes.
You understand the possible penalty for the charge?
Yes.
And how do you wish to plead?
Yes.
Are you pleading guilty freely and voluntarily today? Mr. Bowditch, would you voir dire?
Yes.
Morning, Mr. Kaplan.
What are your asking?
Offense date was October 11 this year.
Mr. Markowski, on October 11th of this year, were you driving, sir?
I was.
Were you driving in van here in town?
Yeah.
Had you been drinking?
Earlier, yes.
What had you been drinking? You,
Yes.
you believe because of consumption of that alcohol, your ability to drive a vehicle is impaired?
Yeah.
Did you take the breath test, sir?
I did.
Do you have any reason to doubt or challenge the validity of that test?
No.
Your Honor, I don't believe we know the test. But, do you believe it was over the legal?
All right.
Yeah.
That's satisfied, Your Honor.
So am I. I'll dismiss the original charge.
Thank you.
All right, Mr. Makarowski, I am going to refer you to my probation department downstairs. They're going to schedule with you to come back for an interview and a sentencing date. Based on that interview, they're going to put together a report and a recommendation of sentence. You'll have a chance to go over that with Mr. Bowditch for your sentencing date. I will have read that report, then we'll talk about that report and anything else you want to talk about before I sentence. You understand all that? In the meantime, I'm going to put you on a personal bond. First two conditions are pretty obvious. One, stay out of trouble. Two, cooperate with the process so we can move you towards sentencing. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond? Yeah. Any questions? You're all set. Go on downstairs. Front counter, they'll call your name, give you those dates. Enrique, you're welcome. Enrique Cano Hernandez.
Thank you, Your Honor. Your Honor, for the record, Jeff Bottom. Yeah. Sir, can you tell the name? Enrique, what's that?
Good morning, sir.
Your Honor, today is the date time set for arraignment in this matter. We wait for the briefing standing. We've also had a chance to pre-trial this case, Your Honor, which is 2022 and 2019 case. On both of these matters, Your Honor, we have an executed plea agreement subject to court approval. In both of these matters, Mr. Cano would be pleading guilty to an added count of no operating license on person, given the understanding the original charges would be dismissed.
Thank you. Sir, do you understand your rights and options? You understand the possible penalty? Understanding this, are you pleading guilty to two counts of no valid operator's license on person? And are you doing so freely and voluntarily today? On January 7, 2022, did you drive a vehicle in Van Buren Township? Was your license suspended, revoked, or denied at the time? On November 4, 2019, did you drive a vehicle in Van Buren Township?
Yes.
Was your license suspended, revoked, or denied at the time? I'll accept your plea to both added charges, dismiss both the original charges. What's the status now?
Your Honor, he's working on, he has to settle an immigration issue, and then he'll get his CDL back. He has to get it on.
Okay.
Your Honor, the only thing that might come in, and I don't know, he was since 2022. Matter of fact, I think this year, he hasn't been incarcerated.
Since 22?
Yes, since 22. Matter of fact, I think it was this year. And I don't know if the judge would, if his incarceration matter the length. I think it was 11 days for this one, but he did 4 months. I think between here and Livingston. Yeah.
How was he in jail on these files?
Here, it was possession of stolen property with harm.
Okay, so you weren't in jail on these charges?
Out of this court, a felony court, yeah.
Understood. All right. Okay. All right. And are you working now? Where at?
Like for myself, self-employed.
What do you do?
Construction, basically.
What kind?
Everything basically except driveways.
Okay. All right, we've got a speeding ticket from 2019, a registration plate charge from 2022, a no proof of insurance from 2022, $1,200 worth of tickets you've never done anything on. Why not? Here.
I was told that's all I had. The driving suspended.
You were told by who?
The judge that I saw for because they put me on diversion.
Okay.
They said you have to take care of these 2 tickets, and that was these 2. I did not.
Okay, well, they might have been talking about misdemeanors.
Oh.
Yeah.
With the civil infraction, if you or if you serve some default.
Oh.
If it's a misdemeanor, you get a warrant. If it's a civil infraction, they just assume you're guilty.
Oh. Well, I have to take care of all of them now, no matter.
Are you in a position to do that?
Right this second, but I can do it within the next 2 weeks.
All right, so those tickets are $1,281. You can take care of that in 2 weeks?
Yes.
Okay, so by the 9th? All right, that takes care of that pile of money. Anything you want me to consider before I sentence you on today's files? All right, normally on these charges, I would assess fines and costs and 4 days on the court work program, but given the fact that we had you for a while on some other files with jail, I'm gonna waive that. You're welcome. All right, unfortunately, because these files are so old and we haven't seen you, you've racked up some late fees and penalties. So on each of these files, fines and costs is $650. I'm gonna let you set up some kind of payment plan or payment arrangements downstairs today. So before you get out of here, have a paper plan on how we're gonna get our money on those. All right, whether or not that's a due date, you're gonna pay it all, or if you're gonna do it over payments, however you do it.
Yeah, I'm gonna make payments on first.
Yeah, yep. But before you get out of here, I need that on paper.
Okay.
You're all set.
Thank you. Thank you, Your Honor.
You're welcome. Aaron, is it Franchuk? How do you say it? Counsel, your appearance.
Good morning, Your Honor. Peace of Sound for on behalf of defendant Aaron Franchuk. You stand to my right. You say your name for the record.
My name is Aaron Stephen Franklin.
Good morning, gentlemen. Tell me about the plea.
Yes, Your Honor. For the purpose of arraignment, like waive the formal reading to stand mute.
Done.
I did have an opportunity to speak with the prosecutor for purposes. We reached an agreement in this matter, Your Honor.
Go ahead.
To dismiss the original 2 counts, it's going to be in section of civil infraction. My client would plead responsible for the double parking.
I see that, and he's agreed to pay fines and costs of $400.
Yes.
All right, I'll do it on the civil infraction, Heather. And can you pay the 400 today?
Okay, next week.
We do 14 days, Your Honor, if that's.
Sure.
Thank
All right, both original charges are dismissed. Hold on, what do we got all here? Except for. All right, you've got something coming up for a review on January 5. Oh, offer sent to attorney on 12/9, must respond by 12/17. Are you handling some civil fractions for you?
Civil fraction?
Yeah, that one I just talked about was a speeding 21 over. And then we got another one. Failed to signal observe, review set for 12/18/25, still in pending status. Yeah, you might want to check those downstairs so we don't miss a deadline.
Absolutely.
All right, have a good day, gentlemen.
Thank you.
You as well.
Thank you.
What's this pile up here?
Old scratch.
Yaman El Ahmad?
Good morning, Judge.
Morning.
Half of Mr. Elmont, say your name for the court.
John Lawson.
So
You just need a new date?
yes,
Okay,
the arraignment, you stand mute when you bring out information.
all right. You working? Go ahead.
He is requesting a court appointed attorney to be trial.
Okay, all right. You're working? Where at?
Lowe's.
How long you been at Lowe's? Heather, can we do a pretrial 212?
Yes, Judge Martin. Is his last name ELAHMAD?
Yep. What time,
Fine to me, or we get different?
No, it's signs you.
Okay.
who, or what time we doing that?
212 is gonna be 9:30.
And you said that's Judge Martin?
Correct.
All right. Sir, I'm gonna put you on a personal bond. First condition and second condition, both are kind of obvious. Stay out of trouble and show up for your court date. Third condition is do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Can you abide by those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond? Any questions? You're all set. Just wait a minute. We'll get you a paper notice. Haley, is it Matthew? Did I pronounce it right? Counsel?
Morning, Judge Dion Patillo, P 82378, on behalf of Ms. Matthew, state your name. Hazel Matthew. So you're not asking your name, stands and you way reading. I have to discuss this matter with the prosecutor. There is an agreement dismiss the original charge of operating while intoxicated, and Ms. Matthews would plead to operating while visibly impaired.
Thank you. Ms. Matthew, did you discuss with counsel your rights and options? You understand all those? You understand the possible penalty for the added charge? Understanding all of this, are you pleading guilty freely and voluntarily today? Counsel, if you would voir dire, I've got an incident date of October 9 this year.
Ms. Matthews, state your name for the court again one more time. And were you in the city of Van Buren Township on October 9th? Were you driving a motor vehicle? Prior to driving that motor vehicle, had you consumed alcohol? And do you believe that alcohol impaired your ability to satisfy?
I'm satisfied too. I'll dismiss the original charge. All right, Ms. Matthew, next step is I'm going to send you downstairs to the front counter. Probation is going to schedule for you to come back for an interview and a sentencing date. All right. I'll also put you on a personal bond in the meantime. Did you hear me do terms on the last one? First one is stay out of trouble. Second one is show up for your court date. Third one is, all right, raise your right hand. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions for counsel before I let you go downstairs? You're all set.
Thank
You're welcome. What was the name on that one I just handed you?
Yeah.
Feldkamp. Stay where you're at. We're just going to get you an adjourned notice date or adjourned date notice. So we'll take care of that. You're welcome.
All right, let's change it up a little bit. Let's go over to 14B in Washtenaw, Magistrate Hillary Braley. Let's see what's going on there.
Yes, Your Honor, Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Shelley. And it looks like Mr. Shelley is currently on mute at the jail.
Okay, Mr. Shelley, can you state your name?
Frank Shell.
Okay, thank you. So today is the date and time set for an arraignment in this matter. And what I am seeing, it looks like you had it's a home confinement tether. And I've got a conditional release violation. I've got a police report here dated December 19th. Attorney Bukovich, do you have a chance to review that?
Yes, I did review the bond violation report that came in through the tether agent this morning with my client. And then speak about the alleged allegation.
Okay. So just so that I'm looking at this correctly, it looks like the address that was provided for the home confinement is an address that your client doesn't live at anymore.
Yes, from my understanding, to speaking to my client this morning, it was an address where he believed he had friends that he knows people there. He believes he could have resided there. However, for whatever reason why he's unable to reside there right now, and I was going to address that when addressing my bond argument.
Okay. You may address bond.
Yes, Your Honor. At this time, Your Honor, I do maybe standing mute as to the allegations. I know today is not the time nor place to really discuss the allegations of the bond violation. However, I do want to note that in the report, it does indicate that my client was going to the address that he believed he could go to. There was the issue with whatever reason why he could not stay there. The one thing I want to highlight and stress is that he followed the court's orders, got in contact with JSC, and was compliant with police officers the whole time, ensuring that he was doing what the court asked of him. So I want to stress that my client is looking to follow court's orders. Whatever misunderstanding happened here with the location should not fault my client for doing what he was supposed to be doing, going from the location to where he was supposed to go. He did provide me a good mailing address. He did provide me the good phone number of his boss. He does have part-time gainful employment. He does indicate to me that he does primarily live in a trailer on a lot. He just moved to trailer there, so he did not have the address for me this morning. However, he does have some form of residence he'll be residing locally in Ypsilanti. So at this time, Your Honor, based upon my client's attempt to comply with that order and his inability to stay at that 1670 address, I was going to be requesting a person of conscience bond. Even though this is labeled as a red bond violation, it's clear that my client was taking all steps possible to do what the court asked of him. So I believe this would be warranting of a GPS tether because it could alleviate any concerns the court has about tracking in my client's location and community safety for the alleged complaining witness in this matter, and allowing my client to return to his trailer and be able to handle this case from out of custody. Because I do believe he does deserve a second chance, particularly because he was doing what he could do to comply with the court order. And I do know that there is an ex-jail, a bond denied for that felony matter. There is a note in there that says he's not being held on that case. So I do not understand why it says bond denied, but there is a note in ex-jail if you click into the case that says he's not being held on that either. Yeah, it's a very weird thing, Your Honor. I just wanted to point that out.
Okay, thank you.
But yeah, I'll just reiterate my request for a person of conscience bond with a GPS tether instead, because I believe my client is warranted of that second chance based upon his attempts to comply with that order.
I would note that this would be chance number 3, as there was a bond violation back in July regarding not reporting for testing.
Yes, I understand that, Your Honor. I was the APD that also addressed that one.
Your Honor, I have to be in court tomorrow. I will go to community corrections as soon as I get out of here. I'll do everything you want me to do. I was trying to.
So regarding, well, I guess a couple things. One is you've been ordered to go to testing. Are you able to do that?
Yes.
Okay.
Yes.
Because it's $12 to test.
Right.
With a photo ID. Okay.
Yeah, he is currently doing odd jobs, so he does have employment to help pay for testing.
Okay. And then the GPS tether being for home confinement purposes, we do need an address for that. So this Center Street address, Attorney Bukovich?
My client indicated me that was an address for mailing purposes.
Okay. But if we're going to be releasing Mr. Shelley on a home confinement GPS tether, then we need an address that works for the home confinement.
I understand. That's why I was asking for it to be converted to a GPS tether, Your Honor. Because he's currently staying in a trailer on a lot without a designated address. It's next to someone's property, so, but he doesn't have a call the address. He just moved his trailer there recently. So that's why I was requesting the GPS tether. Particularly because there was the attempt to go and comply with that court order, and he was in contact with the tracking services with no issues.
I have a phone that they gave me, but I don't know the phone number because I just had it for a few hours. It's in my property though. I can't give you that number. Ma'am, I will go to everything you tell me to go to and do everything you tell me to do. I'd like to just get this cleared up and be done with it. These things are like a year and a half old.
Mm-hmm.
And I understand that. I am going to point out that you were ordered to go to testing back in July and didn't report for testing according to community corrections. So that was when a bench warrant issued for you in August. It looks like the judge arraigned you on that on December 15th and put you on the home confinement tether, and we can see what happened with that. So if I give you one more chance here, that's gonna be the last one most likely, unless the
Yes,
judge.
ma'am,
decides something else.
I do understand that.
Okay,
And we did have a conversation about that this morning, Your Honor, as well.
all right.
Your Honor, I'd just like to get this stuff over and done with and
I can appreciate that, but part of moving things along timely is doing the things the court's telling you to do.
I understand. Yes, I do.
So
While we're waiting for Magistrate Brayley to finish signing a bunch of things, thank you to Barbara for donating $5 on the website. Very much appreciate that.
2026 at 9 a.m. We'll convert the tether to a GPS tether for tracking purposes. Your testing is continued as it was previously ordered. It looks like the judge wants you going to community corrections for testing 3 times per month, and it's to be ETG and substance testing. So, any questions as far as that goes?
No, ma'am.
Okay. And then I'm not sure if this was brought up before, but I am showing a very old no proof of insurance ticket for you. Did we talk about that previously?
I don't recall off the top of my head, Your Honor, if we did or not. Sorry.
Okay, so I'll just make sure that, yeah, well, here first, 05W165101C. It looks like you have a $45 balance. That would be the clearance fee on that. I'm gonna set that for the same date and time so that they can be dealt with together. Okay, January 5th, 9 a.m.
So that's a $25 clearance fee I have to pay?
45.
45?
Yeah. Okay. All right, Attorney Belkovich, anything else or any clarification needed on anything?
I don't think there's any clarification needed on my end, Your Honor, and if it's for my client's reference, remember, tomorrow your court date is at the 14A1 District Court, not at the 14B Court that we're talking about right now, okay, sir?
So do I get to go home today or?
Well, so I'm
Oh, sorry.
granting a personal recognizance bond in this matter. So it's going to be a $20,000 personal recognizance bond. So if you don't show up or if there's another bond violation between now and January 5th, then your bond's going to be at minimum $20,000. All right. But that means this case won't hold you at least.
It's the only case I have.
Okay, then there you go. All right. If you don't have any questions, you're free to go to the door. Thank you.
Thank you.
All right, let's change it up again. We'll stay with the magistrates, but let's go to Clayton County, Georgia this time.
All right, Mr. Bice, you were charged with obstructing law enforcement. That bond is $500. Simple assault is $500. Your total bond is $1,000. Your next court date is on January the 20th. If you do not bond out, if you make your bond, you'll receive notice in the mail when to come back to court. And let's see here. Based on your application, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
Thank you.
Sit on the bed. Next one, come on.
All right, what's your last name?
My last name is Dios.
All right, Mr. Dowes, you were charged with afraid. That bond is 1,000. Riot in an institution is 4,000. Your total bond is $5,000. Your next court date is on January the 21st. I've appointed a lawyer to represent you. Do you have any questions?
Yeah.
All right, thank you. You
got
said yes.
I got a question. So I was in a dorm and a trustee with a white jumpsuit, he came in the dorm. I had my hands inside my jumpsuit.
You can't talk about the case.
And I don't know why I'm getting charged.
Okay, I'll let you know what the allegations are. The allegations are that on December the 20th at approximately 10:55, it was observed that there was a fight between two inmates, yourself and Zuriel Ash. After reviewing the camera, inmate Ash was seen slapping inmate Dowes in his facial area and slamming him on the day room table and knocking him unconscious. Inmate Dowes had a swollen lip, swollen ear, and scratches on his face. Inmate Dowes was cleared by Nurse Ote, and it was determined for him to be placed in the infirmary until further evaluation. Camera footage was placed in the vault. That's what they charged you with.
You see why I don't understand why I'm getting charged.
Yeah, so it looks like they're trying to indicate, I guess, that it was a fight, but the other person obviously was the aggressor. Yeah, they didn't even put anything here about you. You're absolutely right, Mr. Dowes. Your charges are dismissed.
Thank you.
You're welcome.
Wow. Tell me the last time we've seen somebody argue in front of a magistrate or judge like that, and the judge or magistrate go, yeah, you're right, charges dismissed. I'm shocked. Let's keep watching. This is interesting.
Huff, all right. Hold on 1 second, Mr. Huff. All right, Mr. Huff, you were charged with possession of prohibited items. That bond is $5,000. Your next court date is on January the 21st. I've appointed a lawyer to represent you. Do you have any questions?
Ma'am,
All right.
I got the same charge, right? He owned up to his stuff, right? So I don't know.
That's not in the, that's nothing about owning up is in the warrant about your case. It just says that they located tobacco products without authorization on your person. So they don't have anything about that on your warrant.
You can check the body cam, ma'am. So the body cam.
I'm not going to check the body cam. I've appointed you a lawyer. Your lawyer can check the body cam on your behalf and bring it to court. If you walk off now, I'm going to revoke your bond. You don't walk off from court when I'm still talking.
Officer just told me to come on.
Okay, I didn't hear that. All right, thank you.
What's your next one?
Hold on one second. Right. What is your name, please?
Michael Martinez.
Martinez. All right, one second, Mr. Martinez. All right, Mr. Martinez, you were charged with criminal trespass. Your bond is $500. Your next court date is on January the 20th. If you do not make your bond, if you make your bond, you'll receive notice in the mail when it come back to court. It indicates that you do not want to be considered for a court-appointed attorney. Is that correct?
Yes, that's correct.
Okay, so I'll indicate here that you're going to hire your own attorney. Do you have any questions?
Yeah, I don't know. For some reason, the officer said I would have a signature bond, but I don't. Based on the charges, is that was just his opinion? I'm assuming.
Yeah, so family violence charges, the governor of this state does not authorize signature bond on those class of charges. So you didn't qualify based on that.
Okay, and then if I could pay it on my own, however, my debit cards, credit cards.
Yeah, the jail they don't take debit credit cards, but you could facilitate it where you could release your property to someone on your behalf to facilitate that for you.
Oh, okay. And I guess they'll let me know how to do that.
Yeah, so you would just have to release your property to somebody, whoever you trust, to get the money for your bond.
Okay.
All right. Thank you. Good luck. All right, what's your name, sir? The last name?
Porter.
You said Porter.
Porter.
All right, Mr. Porter, you were charged with possession of prohibited items. Your bond is $4,000. Your next court date is on January the 21st. If you do not make your bond, if you make your bond, you'll receive notice in the mail when you come back to court. Appointed a lawyer to represent you. Do you have any questions?
Yes, ma'am. That was my roommate that jail was on here.
Mm-hmm.
Charged it right when they found everything. So that did say that.
It doesn't indicate it. It just says that you were found in possession of tobacco. It doesn't sort out who had it, but that you were in possession of it. So that's something you'll have to dispute at your preliminary hearing.
Oh,
All right. Anything else?
oh man.
All right. Thank you. Take care.
Now, we got one medical personnel that had a medical emergency. So
You said who is that?
Peterson, ma'am.
Peterson?
Yes, ma'am.
So you're saying Peterson is in medical?
Yes, ma'am. He had a medical emergency.
Didn't see anything. Okay.
Your Honor, do you have an add-on for a trace?
Yes, I do.
What's that? That's what? Ma'am. Fine. We got one more person, come see you, ma'am.
All right. All right. What's your name, sir?
Yeah, Ash.
Ash. All right, Mr. Ash, you were charged with a fray. That bond is $1,000. and rioting in the institution is $5,000. Your total bond is $6,000. Your next court date is on January the 21st. I've appointed a lawyer to represent you. Do you have any questions?
No.
All right, thank you.
How's Unit 5? What's up, behind you?
What's your name?
Margot Broderick. Yeah, going five.
Got anybody else on 5 on first offense?
No.
What about 7 and 3?
All right, Mr. Broderick, Miss Broderick, you were charged with criminal damage in the second degree. The bond is $1,000. Battery is $2,000. So your total bond is $3,000. You have special conditions that you can't have contact with Jam and Costin. Do you understand that bond condition?
Yes, ma'am.
Your next court date is on January the 21st. If you do not make your bond, if you do make your bond, you'll receive notice in the mail when to come back to court. I've appointed a lawyer to represent you. Do you have any questions?
Yes, in the regards to the no contact. That's what I have, we live together. How do we go from that? So we live in the same household, children, little ones.
Yeah, so I didn't order you not to live in the residence. You just can't have contact, so he will not be able to come back to the residence, and you'll have to use a third party to facilitate whatever you're gonna do with your children, because both of you have been ordered not to have contact with each other.
So that means he cannot come back to the house.
Not until the solicitor and or your attorneys have an opportunity to investigate the scenario, because you two are both here because of the allegations that are based on both of your actions.
Okay. And
So
does
somebody independent of the court who has no way to verify anything right now. So we have to do no contact until somebody from the state and also your lawyer can see if contact is appropriate.
Okay, can that be done before the court date or before?
Yes, it can.
Okay, and we just get the lawyer to contact the court in regards to that?
Yeah, so your lawyer will know what to do that I've appointed to represent you.
Thank you.
All right, you're welcome.
And this one.
Come on. Thanks, man.
All right, what's your last name? You don't want to tell me? All right, next person. I don't have time for all this, baby. We got 50 people. Next.
Y'all didn't hear my name?
Did you say you? I didn't hear you.
She said Charles.
Okay. All right, Ms. Charles, you've been charged with possession of marijuana less than 1 ounce. Your bond is $3,000. Violation of Georgia Controlled Substance Act is $3,000. So your total bond is $4,000. The marijuana charge is $1,000. Your next court date is on January the 21st. If you do not make your bond, if you make your bond, you'll receive notice in the mail when it come back to court. I've appointed a lawyer to represent you. Do you have any questions?
No, ma'am.
All right, thank you. Take care.
Who's that?
All right, what's your name?
Aaliyah Davenport.
All right, Ms. Davenport, you were charged with simple battery. Your bond is $500. You cannot have any violent contact with Malik Davenport. Do you understand that?
Yes, ma'am.
Your next court date is on January the 20th. If you do not make your bond, if you make your bond, you'll receive notice in the mail when it come back to court. You'll have to hire your own attorney based on your income. Do you have any questions?
Yes, ma'am. Am I eligible for a signature bond? I'm not really sure what it is, but I just.
No, because your charge is family violence. The governor doesn't allow signature bonds on any type of charges that are classified as family violence. And it's classified as family violence because the alleged victim is your brother. So you can't get one just because that's what the governor said. Do you have any other questions?
No, that's it.
All right, thank you.
Thank you.
Come on.
All right, what's your last name? All right, you were charged with criminal trespass on unlawful purpose. Your bond is $2,000. You cannot go back to 1070 Helen Street in Forest Park, Georgia, as a condition of being granted bond. You understand that, ma'am?
Yes, ma'am.
All right, your next court date is on January the 20th if you do not make your bond. If you make bond, you'll receive notice in the mail when it come back to court. I've appointed a lawyer to represent you. Do you have any questions?
No, ma'am.
All right, thank you. All right, what's your last name?
Owl.
All right, Ms. Howell, well, fortunately for you, the officer did not complete the paperwork correctly. So as a result, your charges have been dismissed. I do want to warn you that it's possible the state could have the officer correct the charges at a later date. So don't be surprised if you get something in the mail later. But for purposes of today, the case is dismissed and you'll be released sometime today.
Thank you so much.
All right, you're welcome. Take care.
That's 2 charges dismissed.
Beyonce Matthew.
Need to keep count now.
All right. All right, Ms. Matthews, you were charged with armed robbery. That bond has been denied, and you were charged with battery. That bond is $5,000. Your next court date is going to be on January the 21st. You'll have a bond hearing date if you don't get a bond before then on January the 23rd. I've appointed a lawyer to represent you. Do you have any questions?
You said when is my bond hearing?
The bond hearing is on the 23rd. Your preliminary hearing is on January 21st.
Yes, ma'am.
Any other questions?
Yes, ma'am. My attorney will come see me before then.
Yes,
All right, thank you.
you're welcome.
All right, let's change it up. Let's go back to Judge Middleton.
Good morning, we're back. As I mentioned, this is a pretty full day. There's no pre-Christmas lull here. We're gonna get right to it. Ms. Canfield is here. The defendants are here. Here we go. I hope you like today's first line. It's a good song to sing along to. Good morning, Mr. George. I'm good. All right, we have 2 cases set for this morning, one with Mr. George and one with Mr. Bush. One with Mr. Truckee. But we are ready to address People versus Daniel Gary. Mr. Gary, why don't you come up and have a seat with your attorney, Mr. George?
I just slipped in the shower, put some GROFF in there.
All right, well, I'm sorry to hear that. I'm a little crooked today myself.
Yeah. At 55, I don't know how many more falls it's gonna take before I say no. Like my mom, she's almost 80 and she still does not say no, you know? I'm fragile. She usually lift boulders like that, you know? Landscaping her.
All right, well, give me a minute to get caught up here. This is file 251979 SM, People versus Daniel Gary. Mr. Gary is here with his lawyer, Mr. Tim George. Mr. George has represented Mr. Gary in the past and has had a good attorney-client relationship with him. This matter was charged with domestic violence and interfering with a crime report for an incident that occurred on August 6th. The matter was set for a pretrial conference, then was actually set for jury trial. The defendant entered a plea to disturbing the peace. That plea was entered on December 10th. The other charges were dismissed. Disturbing the peace is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. I left in place a no contact provision with Ashley Brown, who was the complainant in this case. Mr. Gary had a previous disturbing the peace that he had been delinquent in his payments. So I adjourned the matter for a couple reasons. I wanted to have a no contact provision remain in place, and I wanted to see whether Mr. Gary continued to pay on his fines and costs.
Yeah, they should be all paid.
Well, I
I'm
reviewed
sure
this
you do.
morning, you made an October payment, you made a November payment, and you made a December payment. The last payment I saw was December 3rd. There's something more than that. So he was paying on his earlier disturbing the peace. He did spend 2 days in jail in this matter before he was released on a PR bond. I was troubled. Mr. Gary had continued to have contact with Miss Brown, I think through the period up to the plea. So I entered the plea. Mr. Gary then walked out of the courtroom, went outside and called Miss Brown for a ride. And the bailiff said, "You can't do that," and gave him a bus pass. So I haven't heard anything since, but
that lady officer told her not to come. She was giving me the bus.
Well, true. I was like 1 minute later, you went out and did exactly what I told you not to do. Now, I do know that you suffer from autism. I don't suffer, you deal with it. You've been dealing with it your whole life. And you're on the spectrum. You also have some other mental health issues that you've been trying to address.
Yeah, in jail, you don't get your medication, so I mean, it's gonna be really,
So this was reduced to a disturbing the peace, which is normally a fines and costs circumstance. Mr. George, what would you like me to know?
Thank you, Your Honor. And I know that the court has concerns, and I think the prosecutor had relayed those as well regarding some of the contact that had taken place. I think from Mr. Gary's standpoint, he's concerned that if there was any jail time that was imposed, that he wouldn't have the ability to access his medications that he takes. I think for him, at least in the last few conversations we had, his biggest.
Just a minute, Mr. Gary, we'll give you a chance to speak. You need to.
I think he's focused on trying to get things together as best he possibly can to get out of here, get the house sold, and move on. And maybe that wouldn't be a bad thing to change his scenery. I think if the court were, considering some alternative sentence other than the fines and costs, we would ask for a probation instead of the jail time. That would allow the court to continue supervision. If there were any type of services that the court think that Mr. Gary could engage in, that would help alleviate some of those concerns. Those could be done over the course of that probation. But I think the biggest articulated reason for it would be continued supervision from the court to make sure that any orders of this court would be followed. Thank you.
Ms. Canfield, do we have any updated information from Ms. Brown?
Yes, Your Honor. My office has had continual contact with Ms. Brown on the date of the plea, which confirms the information that we all suspected. He'd been living in the home the entire time this case was pending, having contact with her on a daily basis, including on the day that she authored the victim impact statement to this court. That's extremely concerning to me because that's obviously not done of her own free will or done in a setting where she felt safe to communicate with our officer, the court.
The
first time that
she's right here in the building. You can talk to her right now.
I'll give you a chance
She's in
to
the building
speak.
right now.
She's in the building, you
Yeah,
said?
she has to take care of because the paperwork and she got notarized
All
crap
right,
she's doing
so
right now.
just a minute. Is she here in the building?
Sure, you have to take care of her so we can get this house sold and get on it, move on.
Yes.
At least a couple hours away,
All right, would we see if we can find her? Her name is, Ashley Brown. She may be at the Register of Deeds. All right, Ms. Canfield.
Thank you, Your Honor. And what's more concerning also is that this isn't the defendant's first contact with the court. It's not as if he hasn't been in trouble before and understands the court's orders. He was on probation for drunk driving in 2016. He had a use of narcotics and an attempted resisting and obstructing in 2019, for which he received 90 days in jail. And then he damaged a traffic device and pled guilty to that in 2023. Now we're here in an incident where, yes, it was resolved with a disturbing the peace, but it was because her phone was grabbed out of her hand and she was headbutted by the defendant, and neighbors were involved in seeing this occur. So in this particular instance, he also was to have no contact. He's violated that the entire time the case is pending, inclusive of the day of the plea when the court specifically instructed him, do not have contact with Ashley Brown. And then you go out and use a.
I get the state off because she's staying somewhere else. I'm new here.
All right, just a
You know,
minute.
I have nowhere to go. She
Daniel,
had to get gone.
Daniel,
I
I'll give
stay
you a
at the
chance.
house.
I'll give you a chance to
So
speak.
she came over on her free will. You know, she knew better. She
All
had, you know, she had. a place
All
to
right,
stay
Daniel,
and I
just
didn't.
wait.
Okay, sorry, sir.
All right.
Thank you, Your Honor. He just repetitively violated this court's order, specifically after the court told him not to, and he went and used the security phone to call the victim.
Yeah, because she took off with
Stop,
it.
stop.
And she owed me $300 for gas. I mean, for
all right.
water bill. And she goes and spends it all with Josh Brown.
Your
All
Honor,
right.
so
They come back,
clearly.
yeah, and with
All
my
right.
cell phone.
All right.
My cell phone. I was the one with 2 hours without it. Them 2 hours, they're counting on my phone.
All right, Daniel,
All right.
calm down.
There is not a circumstance.
She's right here. She'll verify that shit.
All right.
In which she is safe, given the emotional status of the defendant.
Yeah.
Yeah, just 15.5 years in
All right.
Westville.
All right.
See how you feel. Okay?
Put Mr. Gary back in the lockup.
Yeah, please. I need a break.
Yes. We may give you a break till about Valentine's Day. I want you to go back there and calm down.
Brother.
And Your Honor, I understand the defendant has mental health diagnoses, but we also have to make sure that the public and Ms. Brown are safe, in addition to the defendant not being a risk to himself.
I'd like
I
to
am
hear
gonna
from her.
request a jail
It's
sentence.
always a problem when we take a plea to a reduced charge and then ask for a maximum sentence on the reduced charge rather than the larger charges. But I don't know what side of the fence Miss Brown is on, so I'd like to hear from her. But he's gonna talk himself into about a 30-day jail sentence. So we'll see if he calms down a little bit, and then we'll wait for her.
There was an impact statement submitted from Ms. Brown requesting jail, Your Honor.
I did review it. All right. Mr. George makes a good point. When he goes to jail, they tend to not give him his medication. And then that causes further issues, but they're doing a better job than they have been in the past. Mr. George, if you'd wait for a minute, we'll see if we can find a complainant and we'll take up Mr. Truckey's case.
Yes, sir. I had broken call over register of deeds and she was not over there, so.
Do we know if she's come in the building?
It looks like Ms. Ackerman may be trying to communicate or look for her as well.
Okay. All right. Let's move ahead to our next case, which is Dakota Suarez, file number 252297. Mr. Suarez is here with his lawyer, Mr. Ross Truckey. Defendant entered a plea to domestic violence. He was arrested on this charge on November the 9th. posted bond on November the 12th. So I think there's 3 days of jail credit. The defendant is only 22. He is eligible for the deferral. This was in his relationship with Hannah Lamb. And there was a witness there when this occurred, Mr. Orion Fogg. And Miss Lamb has some emotional issues of her own. Mr. Suarez trashed the apartment, lost his temper, and there was some impermissive touching, and he pled to a charge of domestic assault. Mr. Truckee, what would you like me to know?
Thank you. I think this is the kind of person that the deferral program is meant to help, to intervene in before things get worse. This was a situation where there was drinking going on. All the parties were some level of intoxicated. Things got clearly out of hand. Mr. Lamb or Miss Lamb and Mr. Suarez had an altercation. He came in here, he pled to it. He recognizes that it's not how he wants to live and how relationships should look in his life. So we're asking for the court to sentence to the deferral program, allow him to gain some skills and some perspective on how healthy relationships work and move forward. Thank you.
Thank you. Ms. Campfield, what's your thought?
Thank you, Your Honor. Well, I can say that Hannah is present and would like to address the court. I do think this situation is appropriate for the 769.4A diversion probation. At the scene during his interview, Mr. Suarez appeared to be very upset, very remorseful for what had occurred, and I think acknowledged that he lost his temper. I know that she would like to have contact, and I'd like to have her come up and speak to the court regarding that.
I set this on purpose to do it before Christmas. In fact, both of these I did. And which case are you here on, ma'am?
I'm his mother.
Oh, all right. Any luck? All right. Well, okay, very good. All right. Miss Lamb, what would you like me to know?
So that night we had gotten drunk. We were just hanging out with a friend. And me and him had gotten into an argument over his friend talking to one of my friends that wanted no contact with.
Well, here's the way I saw it, that you confronted him because he had some other woman in the apartment.
No.
And then he went ballistic after that.
No.
So that's what the police report says.
No.
So what actually happened?
So what actually had happened was me and Dakota were at home and we were drinking. We had his
What were
friend
you
over.
drinking?
Huh?
What were you drinking?
Steel Reserves.
Okay.
And we were drinking those. I think he may have had like 3 or 4. I may have had, I don't even know. But we were drinking. He had his friend over. One argument started because his friend wanted to take him to his house, and I was just hoping he would have just stayed at home. And then we were just sitting in the living room, and then his friend Orion had said that he wanted to talk to my friend who lives with me. Her name's Alyssa Pusterman. She lives with me, and he wanted to talk to her, but she wants no contact with him. And so I was telling Dakota that, he shouldn't, his friend shouldn't have contact with her because it's not something she wants. And something had set him off, and he started going ballistic, and we started yelling back and forth. And then I had gotten up to go to the kitchen to get away from him. And that's when he had jumped in front of me and had grabbed a hold of both of my arms. And that's when I told him to let go of me. And the argument had continued to where I had gone into a different bedroom. And well, back in the living room, he was like, going ballistic. He was flailing his arms and his.
What do you think he was so mad about?
I don't know.
Well, I'll ask him here in a minute. Miss Klusterman wasn't there, was she?
She was there.
Oh, where was she?
She was in the. No, she wasn't.
She's not mentioned in any of the reports.
She was coming and staying at my house once in a while, but she was out walking around at this time.
Okay, so she wasn't there when this whole thing went
No,
down.
she wasn't there when this whole ordeal
Okay.
happened. And he was flailing his arms, and his watch had actually come up. He was flailing his arms around. His watch had actually come up and hit me in the underside of the arm. And I had said that he had hit me. And so I had walked into a different bedroom and I was saying, like, dude, you hit me, you hit me. Why would you hit me like that?
Who called the police?
I did.
Okay.
And we were in that other bedroom, and then that's when he had said, like, oh, if you want me to hit you, I can. He raised his fist and pretended like he was gonna
Yeah,
hit me.
something like, you want to see how hard I can really hit you.
And then that's when I had walked out of the bedroom, and then that's when he started destroying my house and everything. And then that's when he was like, oh, you know what, just do it, just call the cops. So I had called the cops.
Now, did he live there or just come sometimes?
He lived there.
Okay, so you were both living at Spring Street?
Yes.
Okay.
And afterwards, he was trying to get Orion to get him to leave before the cops showed up. And then Orion wouldn't take him anywhere. So he just kind of laid on the couch and just kind of accepted it. And then the cops came in and
Yeah,
talked to us. and then
he's
that's
just
when we
laying
took him to
there.
jail.
So do you want me to lift the no contact provision?
Yeah, I would. It was an accident. We were all drunk, and he was. It was just a bad night. I don't believe he has any intentions of hurting me.
Are you employed?
I will be soon at American Axle.
And
I'm just waiting for.
Was Dakota employed?
No.
All right, we'll talk to him about that. All right, I'm glad you're here. Thank you. Mr. Suarez, I can only do that deferral if the prosecutor agrees or accepts it. And in this case, they do. Nobody drinks Steel Reserve because they like the taste. They drink it to get drunk because it's relatively inexpensive and it has a high alcohol content. So you guys were there, having drinks and get drunk, and then many of my stories start out that way. If I took alcohol out of the equation, I'd probably have about 1/3 of the cases I currently have. You've not been in any trouble. You're 22. You're eligible for a deferral. When's the last time you worked someplace?
Like about a year.
Why not? All right, well, maybe it's time to go to work.
Yeah.
I asked her, she didn't know. Why were you so mad?
Because she was taking her, like, talking, like, she was like, just like coming at me instead of talking to him, like Orion, and like, I don't know, it was just, I was I don't know, it was ridiculous. Like, I was like trying to defend him a little bit because they're like, it is, I don't know. Like, I was upset because she should have like I was trying to basically tell him, like, I don't know, talk to him about it, the situation, instead of coming at me.
Well, I'm not sure I have any clearer understanding now than I did then. You did 3 days in jail. I'm gonna put you in the anger management plan. You could use some anger management. If you complete this probation, you're not gonna do any more jail. And you're gonna have the charge taken off your record. I'm gonna order 13 days jail, credit 3. Of the 13 days, 10 are deferred. I got 10 days hung over your head. The fine is 0. There's enough other stuff you have to pay for. There's a $75 crime victims rights fee, a $50 state minimum fee, $150 attorney fee. $480 probation oversight fee, which can be cut in half if you do it in 6 months. You're to pay for the class. So one of the things you have to do is get a job. I'm not sure how a 22-year-old lives for a year as girlfriends without working somewhere, but it's time for you to get a job because you're gonna have to pay for this stuff. 125 in costs, 150 attorney fee, 480. It's 755. And you're to pay for the anger management class. No assaultive or threatening behavior. Alcohol and drug testing as directed, because while you're on probation, you can't use any drugs, including marijuana, and drink any alcohol. You're old enough to use marijuana, you're old enough to drink, but we call this a timeout. If you can complete the anger management class within 6 months, I can discharge you from probation at the end of 6 months. I'm gonna lift the no contact provision. But there is a clause of no assaultive or threatening behavior. So even if you don't hit her, what you did trash in the apartment would constitute assaultive or threatening behavior. So as your lawyer said, we're gonna give you some tools to kind of deal with these anger issues. But you guys are entitled to go out to lunch together. You're entitled to live in the same house. I'm not prohibiting it. What kind of work have you done?
I worked like Meyer, like at other like I've been cashier at a couple stores like Dollar General, Meyer.
I was going to ask you to try to give me a sentence without saying like, but I don't think you can do it. But I think that you're going to be all right. I think you're going to do what I'm asking you to do. I think you're going to complete this probation. I'm going to take this charge off your record. All right, let's take this form downstairs to the probation department. I think I have a little bond money in here. You posted $200 in bond. So you owe $555, and if we subtract $240 from that, would be about $315 that you'd owe in 6 months. And the class, I think it's like $600. It's my recollection, but the probation department will help you with that. All right, you're good to go. Take that down to probation. You guys can go back home together. You can go out to lunch together. I want you to treat her with respect. Christmas is coming. We don't need any of this. No drugs, no alcohol. So you can help him. You can't be sitting there drinking beer and he can't drink. So maybe you can both take a time out. Be good for both of you. All right, you're both good to go.
Thank you, Your Honor.
Let's bring Mr. Gary back. Apparently we didn't find Miss Brown.
No, I was able to make contact with her on the phone. She said that she was not able to come in and speak.
Does she wish to continue the no contact?
Yes.
Okay.
When I spoke to her on the phone, she indicated that she thought jail time would be appropriate, and she made reference to the letter that she mailed you, I believe, on her phone.
All right. Well, you couldn't, that's on the record, sort of. The defendant wasn't here, but that's input from the victim advocate, Kendra Ackerman from the prosecutor's office, and we'll repeat that when he comes in the courtroom. As for Mr. Suarez, I hope he's gonna be all right. All right, Mr. Gary, I put you back there to calm down. To file 251579, people versus Daniel Gary. We did look for Miss Brown. She's not here in the courthouse.
Parking lot. She's in parking lot. Oh, no, at the free store.
Well, they did speak to her by telephone. She is not here. Her position is she thinks that some jail time would be appropriate. And she wants to continue the no contact.
She was happy to hear
that's
from her.
presently in place. All right, so Daniel, can you tell me what you want me to know?
Yeah, man, the basement's a party room. She wants jail, but she just told me before we got here about, probation was good. I mean, we got a reliable car. My mom finally co-signed after 4 cars. That's now she can DoorDash. She got a brand new car. And that was the problem anyways. That was the main fight. I mean, you know, her car kept on breaking down, you know, it was, you know, $700 to what, $1,200 a month. You know,
So your mom,
also my mom co-signed for it.
your mom got Ashley a car?
Yeah.
Or as of when?
What was it? About a month now. And yes, I mean so we had to depend on her. I mean, that was a big issue between us because she kept on breaking down. She went through 4 vehicles before my mom co-signed.
Buying like $1,000 beaters and it just was not.
So you got her a decent car?
Yeah, ever since she got out of the center, you know, me and I already had pre-planned to help, you know, change people in places and things, just at least 2 hours away from here, you know, sell a house and move. All we have to do is.
Well, you mentioned that before, that you'd maybe like to move south and Mr. George.
Or northern Michigan, because I'd be close to her kids, you know, that's the only problem. We just don't want the ex-husband Joshua Brown having that opportunity at least 2 hours away to come, you know, because Ashley don't know not to say no. And he stays, and, you know.
All right, well,
for 3 days, he wants to stay forever.
You mentioned that you discussed this car with her like yesterday?
No, they got like a month ago.
Okay.
Yeah, because my mom just finally had wits end because Ashley was texting.
All right, so she got her a car.
Yeah, she got the car color, the color she wanted.
Since I saw you last, have you had contact with Ashley?
No, it's right before here. That's it.
All right, well, how did you know she was gonna be here today?
Well, because her and my mom, they got paperwork, they got to finish up to sell the house, you know. We had an appraisal, the guy come in sometime this afternoon, actually.
Her name is on the house?
Yeah, it's like a wedding gift, you know. What's about a year now, a little over a year now.
Who put her name on the house?
Right there, my mom owned it.
All right, so you put her name on the house because she was in a relationship with Daniel?
Right.
We're ready, married. I mean, we just wait for Joshua Brown to.
It's actually very good for Dan.
2 hours should be good enough.
Appreciate her more, he doesn't. Appreciate her as much as she should.
Yeah, she's loves doing that. She makes like what, $4 grand a month, you know?
I mean,
crazy.
he's no longer using meth because of
Can't
that.
do wild business. But they do
Yeah, it
now.
was hard sometimes to determine methamphetamine from mental illness.
Right, so when he started
I get
using meth,
excited
that's
about
when he turned his brain to mush or whatever, because prior to that, he was okay. But
All right, again, we've just got voices from the gallery. That's Mr. Gary's mother, who is supportive of him and tried to be supportive of Miss Brown.
Hey, Judge.
Yes.
Because we're getting here, we were talking about support. What's that? What were we talking about? You remember? Because it had to do with trying to look out for Ashley to succeed. She needs to change people, place, things. Born and raised right here. I mean, I had nobody. You know, and so I wanted this. It was a place I died. You know, this is my forever home. And she comes into my life, and I know that I know. I mean, St. Joseph County probably knows Joshua Brown and everybody that's in between all that bullshit. You know, and I'm all about surprising him, man. But she's the last crutch that she's born and raised here. She knows everybody, and she needs at least, and I agree, at least 2 hours away. I mean, it gives you a double thing to take off 2 hours, you know. And hopefully make the right decision, but you know, it's a help because our kids, Josh and Aubrey, I'm trying to be mentor to Josh. You know, he likes to fight and stuff. And for Christmas present, Ashley, I suggested, all I did is we'll go right on for self-defense classes, or, you know, karate. But he chose boxing and sturgis. So he goes 3 times a week. Ashley got to take him 3 times a week from here to sturgis.
Who's that, her son?
Yeah, her oldest son. And best Christmas present ever.
All
Is what we
right.
got.
I
was just a suggestion.
I'm gonna do a fine of 0.
But yeah, they give him a mentor and do right. Sorry.
$75 crime victims' rights fee, a $50 state minimum fee. I'm gonna waive the attorney fee. This was a assault charge reduced to disturbing the peace. The defendant has continued to have contact with her in violation of my direct order. I'm not gonna be able to stop it. Number 12 days jail credit 2, leaving 10 days to serve. We'll put that other on part of the plan. Mr. Gary, you're going to jail right now. You're gonna get good time. You're gonna get out in about 8 days.
Can we do like weekends there? I mean,
Yeah, there will be some weekends included in there, but you're gonna do it straight. You go with the officer.
and what, just a couple days and
Yeah, so
everything
I'm
gets
gonna
solved?
talk to Lauren at the,
What's that, sir?
I'm gonna talk to Lauren from Pivotal. Make
Okay.
sure you get your medication.
I really
but-
appreciate that. My mom will help you with that.
All right, but you were continuing to violate the condition, and I'm not sure this whole relationship is closely related. It was reduced from a domestic assault to disturbing the peace. He's gonna do 10 days, and I'm not gonna try to supervise this probation.
Ashley's at the free store now.
All right, he's obviously having contact, she's having contact. All right, he'll get probably 2 days of good time, so he's gonna be out about 8 days from now, which means he's gonna be in for Christmas. But everybody will have a little peace and quiet. All right, thank you. Mr. Bush, have you had a chance to talk?
Okie dokie, friends. He's an interesting sort. Hopefully, I think Lindsay said he needs to get on his meds. I would tend to agree with that. He needs help, and not the kind of help he's trying to give to himself. That's for sure. So I think we call it a day there. I hope you all had fun. I intend to do a live show tomorrow. It looks like the majority of courts will be there. If nothing else, there'll be extras from today that we didn't see that we can show. So we should be able to put together a show tomorrow. And then the rest of the week will probably be best of. But we will have content in this time slot no matter what all week long. So we'll have stuff for you. Reminder, what I talked about earlier today, you can see on your screen this bunny that somebody set loose that we are adopting. Grandma TCF is going to take the reins on this one. Just waiting for a couple of things to come in, and then a neighbor who's currently taking care of it. I'm going to go get it from them, and it's going to become part of the family. If you would like to help out with that, because Bunny's going to have some needs when we get started. As I said earlier today, any super chats, any super thanks, and any donations via the donate button at courtroomfiles.com will go to that Bunny's initial care. And if there's anything left from that, that will be donated to the Humane Society. So thank you to those who did donate, and just, thank you for being here. I appreciate all of you. I hope we all have a great week. It is Christmas, so let's have some fun here. Let's take care of the ones we love and have a great week. But I'll see you all tomorrow. Take care. God bless.